I'd like to good morning, everyone. I'd like to welcome to reconvene the 31st meeting of the Joint Select Committee on Land and Physical Infrastructure, and to welcome everyone to this second public hearing regarding the 2023 NIDCO report on the extension of the Point Fortin Highway. Putting it briefly, this first session, this morning session, I'd like to welcome also our viewing and listening public to this public inquiry. The meeting is being broadcast live on Parliament's Channel 11 and Radio 105.5 FM, and of course the Parliament's YouTube channel, Parview. My name is Deerup Timal, and I'd like to invite committee members to introduce themselves.
Good morning, everyone. Simon Inobrega, member.
Good morning, everyone. Dr. Ibrahim, member.
Good morning, everyone. Renuka Sagaram Singh Suklal, member.
Okay, thank you very much, members. And just to reestablish, our thoughts from the last session, the purpose of this meeting is to commence the committee's second public hearing pursuant to its inquiry into the 2023 NIDCO report on the Sir Solomon Hochoy Highway extension to Point Fortin project. And today with us we have officials from the Ministry of Works and Transport and NIDCO, the National Infrastructure Development Company Limited. And just to remind everyone that there are 5 major objectives to this inquiry. And for those who are present, as a reminder, and also for the information of the viewing and listening public, these are: 1, to examine the efficacy of the procurement policies and procedures used to implement the project. 2nd is to determine whether due diligence govern the execution of all aspects of the project. 3, to assess the challenges faced in relation to the oversight mechanisms for the financial arrangements used to fund the project. 4, to assess the measures taken to ensure value for money in the contract with OAS. And 5, to examine the reasons for making amendments, addendum to the original contract with OAS. At this point, I would like to just ask the chief officials for the Ministry of Works and Transport, or Permanent Secretary, first, and then followed by the chairman of NIDCO, Mr. George, just for your brief opening remarks, and after which I would, if we can have the introduction of the members of your team here. So we go first to the Ministry of Works and Transport.
Thank you, Chairman. Good morning, Chairman and members and viewing public. We thank you for inviting us to the second reconvened meeting of this committee. As would have been indicated, the construction of the Solomon Hochoy Highway extension to Point Fortin project had its origin in the National Transportation Plan of 1967 and was brought to fruition under the Highways Development Master Plan. This project, while initiated by the Ministry of Works and Transport, has also been implemented, or implementing agency on this project was the National Infrastructure Development Company. We stand ready to answer any questions that you may have in respect of the 5 areas that you've identified. And we want to thank you again for giving us the opportunity to be here.
Okay, thank you, Sonia Yearwood. And before we go to NIDCO, if your members of your team could kindly introduce themselves.
Good morning, Chairman, members. I am Anil Mohan Singh, Acting Director of Highways, Ministry of Works and Transport.
Good morning, Chairman and members of the committee. I am Wesley Gatcheder, Legal Officer, Ministry of Works and Transport.
Good morning, Chairman and members. My name is Navid Ram Singh. I'm a road sector specialist for the Ministry of Works and Transport.
Okay, thank you very much, gentlemen. We now go to NIDCO, Chairman of NIDCO.
Thank you, Chairman, and good morning, Chairman, members of the committee and members of the viewing public. We consider our appearance before your committee today as a continuation of our earlier appearance in March of this year, when we gave a commitment to providing the facts as obtained from the project record of the Solomon Hochoy highway extension to Point. We also said then that we will refrain from regaling you with our opinions and instead confine our reporting to the facts. Today we stand under the same commitment. In this regard, Mr. Chairman, we crave your indulgence today that you will allow us at some point convenient to you in the proceedings to offer some clarification and specificity to a matter on which we were quizzed on the last occasion. The matter to which I refer is the advance payments that were made on the project. Whilst the answers we gave then were correct, they were very general. So now that we have had the opportunity to take a granular look at the record, we will welcome the opportunity to give some specific details as to what obtained with the advance payment. So we will ask for that permission, Mr. Chairman. So we now place ourselves, Mr. Chairman, at the disposal of your committee to provide explanations and answers to your questions that might have arisen from our written submissions. We are at your disposal, Mr. Chairman. Thank you.
Okay, thank you very much, Mr. George. And if your team members can please introduce themselves.
Good morning, Mr. Chairman, members. I'm Esther Farmer, President of NIDCO.
Good morning, Chairman and members of the committee. My name is Dennis Haritran. I'm the manager of the Engineering and Program Management Department at NIDCO.
Morning, Mr. Chairman and members of the committee. I am Ravi Sriram, Manager of Finance, Corporate Planning and Risk, NIDCO.
Okay, thank you very much. Just one or two reminders. It's just for all committee members and officials present. If you can please direct your questions and concerns through the chair. And I'd like to remind members and officials that please, if you can keep your microphones muted until recognized by the chair. The floor will now be open to questioning by members. What we intend to do today is that we are trying, for the purposes of efficiency, to have our questioning fall within certain categories, because I think that would be more productive. And I've heard Mr. George in terms of being allowed the opportunity to provide further clarification surrounding the advance payment. But what I'd like to start off with is the area coming back to the starting up of the contract in terms of the letter of intent, the letter of award, and matters surrounding the award, And after we have covered that, then we'll get into payments. After we have looked at payments, well, time will permit because we have the afternoon session. We want to look at matters concerning the Addendum 1, the first addendum that was issued in keeping with the objectives I outlined, and then land acquisition. We see how the time goes. So I'll hand over to Member Linobrega for him to start his question.
Thank you, Mr. Chairman. PS, Chairman and team, thank you for being here. Mr. Chairman, through you, I would like to start just with a clarifying note. During our last session, there was a lot of conversation around the letter that informed OAS that they were the preferred bidder, and we've gone through that. However, I just wanted to clarify that in that letter, the letter that NIDCO would have received, there's a letter that NIDCO would have received that referred to Cabinet Minute number 33 of February 10th, 2011. And that letter informs NIDCO that the contract has been, the project has been approved, and instructs NIDCO to source funding for the project. That minute nor that letter is a reference to NIDCO having to stop the search for external funding, and that the funding would be provided through the Ministry of Finance and through Treasury deposits. So I wanted us to clarify that as a starting position, because there was a moment of ambiguity in our last session. So, Chairman and PS at Ministry of Works, we have discussed this decision to stop the search for external funding to support this project, and a decision having been taken that the project would be funded through the Ministry of Finance. And I am seeing it in the report that at one point it wasn't only the Ministry of Finance providing funds, but also the Ministry of Works and Infrastructure at the time, and then the RBC bridging loan. But a decision had been taken, and Chairman, in our last session, there was no documentary evidence that you could refer to from the line ministry for that decision. It only appeared, I believe, in the minutes of either a meeting or a special meeting of the board that it had been an instruction. Maybe you can clarify for me, because I don't have it in front of me, unfortunately, whether that instruction had come from the ministry or from the minister.
Yes, Mr. George. Just to interrupt you, Mr. George, your mic.
All right. Okay, so as I was saying, Mr. Chairman, that information can be found in board meeting minutes of board meeting number 59, that is the board of NIDCO, where it is reported by the chairman to the board, and it is contained in minute number 5.3.1. The minute says the President informed the board that the Honorable Minister, Mr. Winston Dukaran, has indicated that the sum of 1.5 billion TT dollars from Treasury deposits will be made available to NIDCO before 28th June 2011 for the San Fernando to Point Fortin Highway. This funding is required to finalize the contract with Contractor OAS Limited, land acquisition payments and operating expenditure of this project. So that is where, so at that time, whatever attempts that were being made by NIDCO pursuant to that note from Cabinet to find funding, so to procure funding for the project, that was discontinued, given that directive here.
Thank you, Chairman. And that leads me, of course, to ask a question of the PS. Ministry of Works and Transport being the line ministry, well, Works and Infrastructure at that time, being the line ministry, my own experience, limited as it is, but my own experience tells me that a major decision like this, to move from an accepted practice of project funding being sought through banks, local and foreign, to move from that to billions of dollars being expended on this, and I'll ask that question after, billions of dollars being expended from Treasury deposits would or should be a Cabinet decision. The Ministry of Finance would want the cover of Cabinet and the protection of Cabinet, and also a document to act as the anchoring mechanism for that decision. Is there any documentary evidence from the Ministry of Works and Transport as it is now that says Cabinet minute number, whatever, from whether it be your own ministry or the ministry at that point or the Ministry of Finance, that a Cabinet decision has been taken to do this?
So, Chairman, through you, member, based on our review in terms of seeking to provide information for this joint select, we have not found such a document. We can continue to look, but at this time, we have not found such a document.
So, Chairman and PS, I made a note here, and I'm glad that you, the Chairman, that you started off the way you did today, because while I commend you, and I do agree that there should be a level of restriction in terms of opinions. However, there is the relevance of a professional opinion, and there is relevance of what is accepted practice, whether it be in NIDCO, in the industry, or in the ministry. So I would like to ask both of you if this is an accepted practice, that a decision could be made as critical, as fundamental, and as far-reaching as that decision is, without documentary evidence that whether it is produced, it is attached to minutes, it should be somewhere to say that a decision has been made. It is not just Minister X told President Y, do this, and it is just done. So I don't know if you can give me your professional opinions on that.
Mr. Chairman, all I can say is that if it were happening today, we would get a document from the, Ministry of Finance. It might be via the line ministry, telling us that funding for the project will be provided in the manner described here, and there was no longer a need to continue to source funding from the sources that we had started with. So, by comparison, if it were today, we will get that in writing. Though that information that the President shared might have just been advance information, but it would have been supported or it will be supported in writing if it's today. And that seems to be a good way to do it.
Yes, member. I am tempted to say ditto, because today, at this point, this is how we normally proceed with matters such as this.
I appreciate it, Chairman. There's one other question that I would like to raise. There was also a conversation around the timing of the letter of intent and those payments. And we received a document from NIDCO, I believe. And in that document, and again, Chairman, I have to apologize to you, but I'm sure you will be able to know which document it is. But it basically sets out the rationale for the letter of intent. And again, that rationale refers to the desires of the Minister of Works and Transport at the time to get this job going, to have the job started. But I wanted to confirm a timeline issue I have. On February 10th of 2011, Cabinet approves the award to OAS. On February 10th, 2011, Cabinet tells NIDCO to go and source the funding. But on February 24th, as referred to in one of your documents, it is said that OAS has mobilized to site. You're with me, and I am on the right track so far? So I haven't gotten those facts wrong. So OAS has mobilized to site 2 weeks after Cabinet has approved the award and Cabinet has told NIDCO to source funding. My question is, how could OAS mobilize to site without instruction from NIDCO? Or, well, I'm assuming at this point, PS, that this would be an instruction from NIDCO. But if at any point there is an instruction that comes to NIDCO from Ministry of Works and Transport, you can say that as well, right? So how can OAS mobilize to site without instruction from NIDCO, and that being a formal contract, start dates, all of these things? That would include also dates to mobilize. And how could NIDCO allow that without direct involvement or instruction from the line ministry? I suppose, Chairman, in my reading of it, it feels almost to me as if in this instance, OAS was trying to force NIDCO's hand to advance the project in whatever way they could. And further to that, and this is also from Ministry of Works, is there any document, instructions, documentary evidence from Ministry of Works instructing NIDCO to allow OAS to proceed, or any document from OAS to NIDCO or to the Ministry of Works outlining the reasons for their having mobilized to the site on the 24th of February without any contract being in place, without any of these things to formalize the arrangement being in place?
Who's going first, Mr. George or Ms. Francis? Or Mr. George?
Mr. Chairman, I was a bit taken aback when I saw that. And when I say that, what do I mean? There is a minute that we have here. I'll just describe it, and then I'll be told what is the number of the board minute, where the minutes of the board meeting, where the president was reporting to the board that OAS had started in the sense that with the site accommodation in Golconda. And that was stated long before anything like the approvals or the instruction to proceed was given by NIDCO to OAS. So I was a bit taken aback when I saw that. Right. But in terms of the cabinet note, not the cabinet note, the cabinet instruction 3, what is it now? The cabinet note that gave, yes, that one, that gave approval to the budget and authorized NIDCO to go source the funds. That information went to NIDCO's tenders committee. The tenders committee took it on board and then operationalized it. And they decided, or they recommended that, the LOI and things like that should be given to get started. And that information would have been reported to the board now. So you have a tenders committee, they meet, they make suggestions, they don't decide, but they make suggestions and recommendation, and that goes to the board, and the board will approve or reject. But in that case, the board approved. And so that is above board in terms of how things happen, so the LOI started from that. So in terms of starting of the LOI, there is a procedure that was followed. But I found that the timeline for those occurrences that happened around that February date, very fuzzy, right? And that was one of them that I found was a bit strange.
Thank you, Chairman. Piers, I don't know if you have anything else to add to it. Sorry, Chairman, through you. My apologies.
Okay. Not really, Chair. I asked NIDCO to go first because NIDCO would have laid out the process. Because once it is that the matter has come to the ministry and then is submitted to cabinet makes a decision, and then the company is then given the go-ahead. It's the company that then enters into the agreement with the contracting firm, and as such, instructions, etc., will go via the company.
There was one other issue I just wanted to raise, and we can have a further conversation about it as well. And it's also a matter of clarity. So, Chairman, when we discussed that actual letter that was sent to OAS informing them that they were the preferred bidder, and we have already established that that letter that would have been sent on May 25th would have been in contravention of a board instruction as to the preferred bidder not being contacted or any discussions advanced without a non-objection. We had spoken about the letter and who would have been approved or authorized to sign that letter, and the letter was under the title of the Secretary of the Tenders Committee. We've established who that person was, Mr. Harris, but what may have passed in the conversation was that it was not Mr. Harris who signed the letter. It was somebody who signed on his behalf. I'm correct, and I have actually seen the letter now with the signature, and the signature does say 4, right? Did we ever establish, not we, was it ever established who the person that actually signed that letter was? And was there ever any investigation as to why that person would have signed this letter in contravention of a board instruction, which may have been followed by whatever internal disciplinary actions or anything like that? Have any of those issues ever been identified?
No,
Yeah, please.
Mr. Chairman, the answer to that question is no, because we thought that the person who is signing on behalf of Mr. Harris is not as critical to us as it is that the letter was issued. It was copied to certain key persons, and I mean, the person who is signing could be the secretary for that matter, you know. But what was also important to us is that, yes, the letter was given, but it was retracted by what is it, the 30th of, yes, by May 30, it was retracted. And it was, do we have that in there? What is the appendix, please? All right, and the letter of May 30, 2010, that retracted that letter of, well, informing the OES that they were the preferred bidder, that was issued then by Ms. Keisha Inns, who was the president of NIDCO, and that is in your bundle. So it was retracted. We did not waste any more time. Well, not waste, but we did not thought it necessary to find out who exactly signed that for Mr. Harris.
One last thing, Chairman. Mr. Harris would have been employed at NIDCO. He's the secretary of the tenders committee, but I don't think that he would have been employed in that position. Did he have a substantive position within the organization?
Mr. Chairman, Mr. Harris was the procurement manager.
Was the procurement manager?
Yeah.
Okay, thank you.
Thank you, Member Ibrahim.
Good morning, all. Just coming back to the tight timeline between February 10th, 2011 and February 24th, 2011, where the funding, where it was instructed for NIDCO to pursue funding, subsequently receiving instruction that it may no longer be necessary and it will be coming from direct deposit from the Treasury to mobilization. I am just curious to know, between the 10th and the 24th of February 2011, how much money, if any, was paid towards OAS to go about that level of mobilization on site?
Mr. Chairman, in answer to the member's question, no monies were paid to OAS during that period. What happened after the LOI was issued? The records show that the project manager, or project manager stroke FIDIC engineer ACOM, they issued a letter to the contractor pursuant to that LOI, laying out the start date for works under the LOI, and that was established as March 28, 2011. So they were saying, okay, this will be your start date. And in fact, they used the word which says what it was memorialized as May 28, 2011. Sorry, March 28, 2011. So that would be the date from which, and at that time, an advance payment of $7.5 million was paid to OAS. So he got an advance payment to the LOI payments. And that will explain, Mr. Chairman, why we reported 2 payments under the LOI. But you, Mr. Chairman, you might have followed the money and you saw 3 payments going to going to OAS. Well, that is it. The first one was an advance payment of 7.5, and the other 2, those were payments that were made to OAS for works done under the LOI. So the start date was March 28, 2011.
So there was nothing untoward for mobilizing about a month before, prior to that March 28th. It was just the company getting the ducks in a row to start the project.
Mr. Chairman, where the fuzziness occurred, OAS had apparently started works, mobilizing and things, even before. So it was not a case that he got the LOI and he started. It was before the LOI was given, unless they made mistakes with the dates. But that is what the timeline will show.
So let's see if we could clear up some of the fuzziness here. Mr. George, the letter that you referred to that was issued by AECOM to OAS, would it be possible to provide this committee with a copy of that letter? I don't think we have a copy of that letter.
Mr. Chairman, being told that is it in Appendix 11?
Yes, Chairman, through you, those documents, both notifications are found in Appendix 10, would be the first notification, and Appendix 11 would be the notification of the 30th.
No, Appendix 10 is the letter of notification to OAS. Now, that letter of notification, was it specifically concerning the LOI, the 90-day, that kick-started the 90-day period? Because we also have a conditional letter of award. You see, I had raised this matter at the last hearing, because the particular conditions of contract, according to the FIDIC Yellow Book, has a letter of acceptance. That's the term that is used in FIDIC Yellow Book, letter of acceptance. But then that particular clause with that definition of the letter of acceptance was removed through the particular conditions of contract. And then now we have conditional letter of award, letter of notification, conditional letter to proceed. I mean, we have so many different terms that are not defined, that is not defined in particular conditions of contract, you see? And I think that is leading to some of the fuzziness that Mr. George is talking about. But coming back to what Member Ibrahim was asking and what Member De Nobrega was asking, Mr. George, we thank you for the response that you provided subsequent to the last hearing. And there is, you did include minutes of the third meeting of the Tenders Committee held on 25th of February 2011. This is NIDCO's Tender Committee meeting. And then you also have a note that you provided the committee with. And the note that was provided in your response, it is titled, "The matter for consideration of the Tenders Committee is to consider and approve a conditional letter of award by OAS, letter of intent to be issued by NIDCO, and ratification of the RFP for securing project financing." And under background, this is the NIDCO document, it says that the Minister of Works and Transport has conveyed the desire of the government of Trinidad and Tobago to expedite work on the San Fernando to Point Fortin highway project and requested urgent mobilization of such works. It should be noted that a significant impact of the works to be undertaken on the construction of the highway is expected to be the stimulation of the construction sector and the economy as a whole. Indeed, such activity is urgently needed at this time. So I'm reading from the preamble from the report that was presented. And under the heading Recent Developments, it is stated here, this is a note to the Tenders Committee of NIDCO, from NIDCO itself, this is from This is from the president at that time of NIDCO to the tenders committee. And it states that on Thursday, 24th of February, 2011, OAS mobilized equipment at the Golconda end of the project and wishes to commence construction of their site office. So it is actually stated here by the then president of NIDCO to the tenders committee of NIDCO that OAS had already mobilized on February 24, 2011. And this note is dated the 25th of February, one day after. So coming back to the whole question of NIDCO, this suggests that NIDCO was aware that the contractor had mobilized. Now, you use the term fuzzy, but in terms for a contractor to mobilize, it's a couple of things. One is that we would have had to give possession of site. Normally, under normal contractual arrangements, contractor would have had to be given possession of site, one. And then, in terms of the contractor actually mobilizing, because this comes to NIDCO's tender committee on the 25th. So I think it's clear here that the contractor had already mobilized prior to the tenders committee of NIDCO. It being brought to the tenders committee of NIDCO for approval. So it's both a question for you, Mr. George, and also for Ms. Francis Yearwood. Are you in possession of any documentation or any instruction as to what would have brought the project to that stage where the contractor would have actually started mobilizing without any instruction being given, formal instructions, or if there is, if you are aware of any, to what extent prior to this date was NIDCO involved in discussions with OAS, if any discussions prior to this date regarding mobilization? Or the same goes for the Ministry of Works and Transport. Was the ministry engaged in any discussions directly with the contractor, with the intended contractor, OAS? That would give them the confidence to actually mobilize for a project before any formal instructions.
Mr. Chairman, I can find, or we have found no record, nothing on record to suggest that a formal written instruction was given to OAS. The document from which you quoted, Mr. Chairman, well, although it's described as, the matter to be considered the matter for the consideration of the tenders committee, that really is what the tenders committee issued to the board for the board's approval. So in that tenders committee, and at the back of that, it is signed off by the right. Okay, so that sort of information was being maybe presented to the tenders committee, and I note that the president at the time, he was a member of the tenders committee, not member, but he sat on the tenders committee. So he could have given them the information, well, I'm speculating here, and then they took that body of information and sent it forward to the board for the board's approval. And what you have here, the document that we referred to, is where the board is signing off on it and saying, well, yes. But no, there is no record, nothing on record to suggest that a formal authorization was given to OAS to commence work, to mobilize partially or other. No such authorization was given. And it was certainly not given in February. the letter that we are referring to is it was called what? A limited, what is this? Limited notice to proceed. Isn't that in the document somewhere? All right, I'm told now, is where? It's in Appendix 19, Mr. Chairman.
Yeah, but wasn't that limited notice to proceed? Wasn't that in relation to the substantive contract and not the works under the LOI?
That is another area, Mr. Chairman, of confusion. On the face of it, it will tell me that that's, as I said, limited notice to proceed. It is the notice to start the works under the LOI. However, subsequently, that date of March 28, 2011 is being used as the date on which the contract started. I have argued that it cannot be, because at that time it was limited. He could not have engaged the works as a contractor will be able to engage the works when he is authorized to start. But I was told that it was agreed between OAS and NIDCO that that will be the start date of the contract. So although it was limited to start works under the LOI, it was subsequently used as a contract start date for works under, is it phase 1? The contract date is the 4th. We know that. Mr. Chairman, I will just defer to the President. She has some information she wants to share.
Sure.
President.
Mr. Chairman, the March the 28th was the date of the limited notice to proceed. On July the 4th, 2011, when the contract was signed, the engineer gave a notice to proceed for phase 1, and that became the replacement, so to speak, of the limited notice to proceed. That became the first notice to proceed under the contract, and that's based on a letter dated July the 4th, 2011. Sorry, sir.
Yeah, Ms. Yarrow, do you want to say? No, because Mr. George, you go ahead, please, Ms. Yarrow.
Yes, Chairman. We are really, I don't know if I want to use the word suffering under the fact that this project, the time span, and the fact that none of us were actually there, and we are therefore relying on documentation and practice and normal procedure. So you asked the question as to whether or not the ministry could respond to whether or not there were discussions for the early mobilization date, I think, of February the 24th. And I must say that we have no documentation, as the chairman would have also indicated, which refer to discussions for early start. And we definitely have no documentation which specifies and states any written early start on the 24th.
All right.
Mr. Chairman, I have just one thing to sort of bring to your attention. I've heard what the President has said. But when you look at the record, in our document, in our RFP and what have you, it speaks about price escalation. It's not, all right. And the document says it will not be applicable, and that is in accordance with clause 14.7 of the FIDIC Yellow Book conditions. It says it will not be applicable in the first year of the contract. It will kick in after the first year. When I look at the records and I follow the money, I see us paying, or in our computation, I see price escalation sums being applied to April 2012, and certainly April is before July 4. So if July 4 were the official and real start date, clause 14.7 would have kicked in, not in April, but sometime after July 4. You understand what I'm saying? So based on their reckoning, they are saying, okay, and they are giving credence to the fact that the March 28th date was the date that they used as the start date for the contract.
Okay, now, okay, so no, we appreciate the difficulties because of the time period, and I mean, you all are going by in terms of what documentation you have been able to put your hands on to find. But, you know, one question I would like to ask is that in the leading up to the LOI, and in fact, in the actual letter of intent that was issued by NIDCO, based on what came to their board and based on the recommendation of their tenders committee, I am still trying to find and sift through what has been presented, the role of AECOM at this stage of the project. Because AECOM was already contracted by NIDCO to provide project management consultancy services. And if there were negotiations going on with the contractor to mobilize, there were discussions with the contractor about introducing a letter of intent to kickstart the project for reasons that are given as urgent. The role of AECOM in issuing any official instructions as the engineer under the physical conditions of contract. To me, there seems to be a gap there, Mr. George, in terms of AECOM's role at this stage of the project, despite the fact that they were already engaged as the engineer on record.
Mr. Chairman, it will appear as though at that stage, NIDCO, through its president, and, well, after the president will lead the charge and things will be spoken about or even decided, it will go to the board, and the board will ratify or approve, and afterwards, it will seem to me that AECOM came into the picture more to activate the decisions taken. That is not to say that AECOM was not on committees where, well, all right, let me give you an example. So AECOM was part of the evaluation committee. We have an evaluation report. Not evaluation, sorry. They might have been there, but what I want to talk about is not evaluation. AECOM was part of the negotiation. There is a negotiation report that talks about two issues, I think, but one was certainly advance payment. Coming out of that committee, there was a report that said that was an unresolved issue. AECOM was there. And then later on, when the thing is eventually resolved, what you're hearing is the minister says to accept the 20, to apply whatever percentage he said. At that time, it was 20. But coming out of the meeting where AECOM was present, they were saying that they did not agree, they didn't approve, moving from the 10%, right? But eventually, the minister said to use 20%, and then 20% was used, and thereafter, well, AECOM just implement. So I'm saying that, yes, AECOM is there, but they seem to have been in the background, so that when the LOI was given, their letter came after, right into the contractor, talking about the limited notice to proceed, talking about the March 28 issue. So all of that was just the fine details to implement decisions taken where they might not have been playing that leading role then.
All right, but then the decision to pay an advance payment on the $15 million LOI matter, right? Which is 20%. Yeah, 20 of the 50 million. 7.5 million was the advance payment. 15. Yes. Okay. Thanks. 15. You see, I'm not coming across anything where that was discussed, that was worked out.
You're correct, Mr. Chairman. There is nothing that I can lay my hand on to suggest that that was discussed and it was decided and then implemented. I couldn't understand, well, why 15? Why not 10 that we started with initially? Of course, the 10 moved to 20% later on. So why not 20 or 10? Why 15? But that is what it is, and that was just paid, and I can see not justification, nothing on record to suggest where that authorization came from.
Okay, thank you. You mentioned a 10% advance payment. That was mentioned where? Was it in the RFP for bids?
Yes, Mr. Chairman. It was in the RFP. And you can find that, Mr. Chairman, in Appendix 6.2, I think. Or better yet, if you go to page S4.4 under Section 4 of the RFP, so page S4-4, that talks to the contract information appendix, one will see there that the advance payment stated there says not to exceed 10% of accepted contract.
Right.
That's what's stated there.
And then during the negotiations, right, the agreement, it came to a final agreement of 20%. I think there's a report from the negotiation team in which it states that actually the report of the negotiating team. I'm not sure what appendix it is. Sorry about that, but within that report, the report of the negotiating team, on page, well, it's in Roman numerals, it's 6 to 8. It is stated here that NIDCO and OS arrived at a settlement after NIDCO's consultation with the government of Republic of Trinidad and Tobago that the advance payment will be 20% of the total agreed. So it's actually documented here in the report from the negotiating team, where it is stated in consultation with the government that a 20% advance payment was agreed.
Mr. Chairman, I want to again draw our attention to meeting number 56, the board minutes of meeting number 56. The President reported under the rubric advance payment for the project, item 5.1.10, and that is dated 17 February 2011. And on 17 February 2011, that board meeting said, 5.1.110.2, it says, NIDCO has been advised by the Minister of Works and Transport to agree to the 20% advance payment as requested by OAS. That is what the President is reporting. So when I hear they tell me that the report say that they had a meeting and they arrived at that, I don't know how the report could be saying that here now. You know, when, as early as it's February 17, you were advised, you were instructed, you were told to go to 20%. Yeah, but when you're reporting it, it cannot be reported as though, well, you had some negotiation then. You didn't have any negotiation. You were directed to go to 20%.
No, the report of the negotiation committee is dated 24th of January 2011, right? The board meeting you're referring to is what date?
17th of February.
17th of February.
Yeah.
2011, right?
Yeah.
Right, okay. So it would be after this negotiating report of the negotiation committee. 24th of Jan. So within this report, as I read out, actually the negotiating committee did enter into discussions with OAS about the advance payment. And the question that I would ask is that if you base your bid on 10% advance payment and you come away with a 20% advance payment after negotiations, shouldn't that reflect in some cost savings on your final outcome?
Mr. Chairman, what's the name? OAS seem to have been in the driver's seat. Of course, what you're saying is correct. So I'm hearing now the rationale, the justification well, because one has to be found. So the justification that we are being given now is, one, it will hedge against price increases. In fact, they went on to say that they're going to cap, what do you call it, cap? Escalation, to, I think 350 million. Yeah. They went on to see that. They also said that it's going to secure what? Cost ending. It's going to fix their costs, hold their cost ending. What? Well, yes, they identify 4 items. So the point I'm making is, OAS immediately after, so OAS is negotiating now. And OAS says, listen, I want 20%. And because we have to sort of guard against price increases, and they listed four items. I think concrete, steel, asphalt, and aggregate. Right? That's what they listed. And they said they want 20%. All during the time that they are making that making that request, NIDCO is resisting it. NIDCO is saying no. Suddenly, well, not suddenly, after this thing appears, then NIDCO is saying, well, yes, you'll get the 20%, and we're going to cap the escalation at 350 million, $315 million TT dollars. And what is the actual money that was spent in escalation was 16 million. 16? Yeah, $16 million. So it was a cap given, yes. It says your insurance company, your insurance coverage on your car, you have a nice coverage, but your excess is so high that every accident you have, you'll never get to use the insurance company's money. You'll always have to pay the first amount, right? So that is what I am seeing. And this thing gets curiouser and curiouser, you know, because, we heard about, okay, the meeting that was held on the 19th. But we have a draft note going to the cabinet, a draft cabinet note written by NIDCO going to cabinet. The date of that draft note, could one on the 18th. Could we get it? And on the 18th, it is stating what is going to happen on the 19th. So I'm hearing that, okay, they had a meeting on the 19th, they had a meeting on the 19th, but could someone get just, and I'll read what that draft cabinet note to cabinet said. You have it there? Just give me a 5 minutes. Where's the document you have?
Mr. George,
Yes.
no, I think coming out of the line of questioning and the responses that are given, I'm not sure we're heading in the direction of clarifications, or it's becoming a bit more challenging. So what I will suggest, in the context of the discussions, that when you look back at what is being discussed at this time, that if NIDCO would like to submit, clarifications in writing with definitive reference to documents, I think the committee would be quite willing to take that on board. But what I would like to ask you, Mr. George, at this time, is that just based on the discussions and in terms of entering into, based on your experience in the field, and in terms of entering into negotiations with a preferred bidder, and taking into account the kind of concessions to move from a 10% advance payment at 20%, to be discussing escalation, taking into account those factors, would you think that it was unfair to the other, unfair to the other contractor that was the second option, GLF, where negotiations were to such an extent that did it create a disadvantage?
It might not have, because I say why. The GLF methodology was to come in and do contract management. So they'll come in, do contract management, and employ local contractors to do the work. So in hindsight, that might have been a better way to go. But at the time of evaluating what you had before you, that was a sort of deviation from what maybe the expectation was and what the other respondents were proposing, where they coming in and be the main contractor. And if they have to use subcontractors, they will, of course, seek the approval of the FIDIC engineer and get to use them. But GLF's approach was to use, come in, do contract management, and employ local local contractors to execute the work.
Okay, so, I like to, we get more into the matters of payments, but, just coming back to the question of the advance payment for the LOI, or the 7.5 million US dollars. We have not come across any certification for that payment by AECOM or anybody, as a matter of fact. There was no certification for that payment. Am I correct? That no certificate of interim permanent certificate was issued for that 7.5 million.
Yes, Mr. Chairman, there is a certificate, but that certificate was not issued by AECOM. It was issued by NIDCO, and it was signed, of course, by by persons in NIDCO who would have signed, who countersigns IPCs that come from AECOM. All right, so it was generated there and paid there, and you know, certified by those persons and sent forward.
Was not, I think we established that AECOM was on board fully during all this time.
That's correct, Mr. Chairman. AECOM was present, but they did not issue that IPC. IPC under LOI was issued by AECOM. IPC 2 was issued, but that one in particular was not issued by AECOM.
Have you come across any reasons for such a decision by NIDCO?
None whatsoever, Mr. Chairman.
All right. The second thing is that was there any security provided by OAS for that 7.5 million US dollar payment?
Yes, Mr. Chairman, there was security. It was given by, is it Republic Bank? Republic Bank, and it came via, is it a standby letter of credit? A standby letter of credit. So it was secured.
Okay, thanks. All right.
Mr. Chairman, if I might just, you know, well, I found the document. Mm-hmm. So, talking about fuzziness. So this is a document that went as part of the draft cabinet note talking about the project and getting cabinet's approval to apply, to approve budget and what have you. And the draft cabinet note attached to it was an appendix, you know, appendix 2. It was dated January 18, and it was what they call the interim report. And it says, a special meeting was held between the parties on Wednesday, January 19, 2011. The final agreed to amount will be duly covered by an on-demand advance. Well, the point I'm making here is that is, you know, as I said, people were probably careless with dates. So you get all these dates maybe, you know, so you're writing a report, January 18, and you tell me a meeting, not is to be held, you know, was held on January 19.
All right, so let's move a bit more into the payments aspect under this the particular contract with OAS. But before we do, Mr. George, at the beginning, in your brief remarks when we were starting, you did indicate that you would like the opportunity to offer some clarifications regarding the advance payment. Have we covered it in our discussions thus far, or do you want to summarize?
Well, Mr. Chairman, we have covered it, and in the interest of time, we can move on.
Yeah, okay. Well, I would start off here, and then, or let me invite Member Saga.
Thank you, Chair. You know, through you, Chair, you know, Mr. George, you've been trying your very best with, of course, the information that is before you to respond to questions directed to your good self based on what would have happened many years ago. I've been listening to this conversation, of course, by submissions made by your good self, of course, questions posed to you all by the committee members. And to my mind, clearly we have moved beyond fuzziness and gray areas to what now seems to be downright junjat that existed in the manner in which this contract, was awarded, payments were issued. And that, of course, remains of serious concern to me as a citizen of this country, bearing in mind how much money was expended, to OAS and in the overall execution of this contract. So certainly we have moved from fuzziness to another layer of chaos. Certainly no fault of yours, Chairman, because you have been very helpful with the information that you do have on record in providing us with some clarity, on certain areas. But before I jump into a little bit on payments and receipts of payments by OAS, I just want, just as a matter of the record and just for clarity in my mind, because I would have explained the chaos that's happening in my mind, a question directed, of course, to the Honorable Permanent Secretary, through you, Chair. So it's clear to say, just as a matter of restating and summarizing, submissions and questions posed to you by, my colleague, fellow member Nobrega, is it clear to say that there were practices at that time, general practices and procedures that certainly departed from what you understand to be best practices in the ministry? And I make specific reference to, for example, instructions given to NIDCO in the absence of reference to cabinet decisions or cabinet minutes. Is it fair? Is that a fair statement or a fair understanding?
Mr. Chairman, that would be a fair categorization of what happened
Okay.
during that period.
Okay. And now to the point of OAS being mobilized, and my understanding to date, based again on the discussion we have had all morning, is that there's no written instruction. OAS is mobilized. There's no documentation on the record that suggests at all where they are acting or where they receive this instruction from in order to mobilize. Is that also a fair statement?
Well, I just want us to bear in mind the limited
Letter.
notice to proceed.
Save and accept that.
Yes, there is that, yeah. Mhm.
Okay. Now, I know this committee certainly will not call upon you to speculate. Certainly we would not do that. But, I mean, OS, there's this limited letter to proceed, but yet they are proceeding, full speed ahead, mobilizing. To my mind, I'm wondering, they must be receiving instructions from some entity. It's certainly not from NIDCO, because I can't fathom that a contractor, especially a foreign contractor, operating in a jurisdiction outside of their domestic domain, comes into a foreign territory and just, Chair asked a question very pertinent concerning when OAS mobilized, they would have had to have access to, to be able to mobilize to the sites and all of that. But we have this limited letter that you have referenced, and save and accept that OAS is mobilized and they are acting and they're continuing to, they have begun their scope of work. I mean, again, not asking you to speculate, but doesn't that suggest to you that outside of NIDCO, perhaps OAS is having conversations or receiving instructions from another entity or another person that they deem or persons that they deem are in a position to give them that instruction and go ahead or green light to act in the manner in which they did? Because that is a confusion, that's a question, a recurring question in my mind. If they are not getting the instructions directly from NIDCO, even apart from the letter we spoke about, I mean, where is this instruction coming from? I don't think they boldface just to, go through and begin mobilization without having something to predicate that move on. I'm not sure what your thoughts are, Mr. George, on my confusion.
Sorry. Mr. Chairman, based on the record, it is clear to me, as it is probably clear to the members as well, that OAS had enablers that were maybe powerful. They were enabled, and coming out of what decisions were taken, those decisions will then be ratified, so the NIDCOs will come in, so that when you go to the board meeting and you talk about OAS has, but the board has not really confirmed or even approved. Well, poor board, what are they to do? They will just ratify. So I'm saying, but who spoke with OAS? And I'm saying that whoever spoke to OAS must have been a sort of could be authoritative figure, somebody with authority to be able to give OAS the go-ahead. I mean, how could you be mobilizing equipment and what have you onto Golconda when you do not have that bit of paper in your hand, not even a limited notice to sort of proceed?
No,
and in fact, I'm being reminded here that the limited notice to proceed came in on April 13,
That is what, if you recall my line of questioning,
Yeah.
from what I recall when I looked at the letter to proceed, I knew it came much later afterwards.
Yes, and that limited notice
And you
to
all were
proceed.
raising the letter to proceed to say, well, maybe that justifies the starting
Yeah.
of the whole thing.
Yes, that limited notice to proceed came on April 13, and it talks about a meeting that was held, I think is in March, between NIDCO and OAS, so as though it was, well, reporting long after the fact that following that meeting, hey, here is now your notice to proceed, your limited notice to proceed, which morphed into the notice to commence the contract later on, because that March 28th date is being used as a contract start date later on.
All right. I think we're coming back and looking back at things that we'll discuss a bit, but I think just to summarize it is that as far as NIDCO and the Ministry of Works, you all have not come across any documentation in the lines of the questions that have been asked.
And there's also the suggestion, again, because you made a very strong comment, it seemed to be a situation where OAS may have had enablers who could have, upon whose instructions they may have been acting. And that suggests to me, and I could be wrong, because again, just like yourself, I'm grappling with all this information. It seems as if at this stage, NIDCO is just a rubber stamp, because they are not given instructions. They are not even party to the instructions. It seems to me as if there's some enabler who clearly is a big Sawati, and I know I said it in passing because, again, OAS feels they have the authority to act, to mobilize. And then NIDCO is just here, none the wiser, and things are happening right under them. So it seems to me now that at this stage in the contract, NIDCO appears to really just be rubber stamping decisions that are coming from some other superior source. I'm not sure what your thoughts are on my interpretation of what information is now placed before the committee.
Mr. Chairman, I would say part of NIDCO might not have been part of the enabling team, but NIDCO could have had components on the enabling team. But, you know, it's certainly not the board, because the board was very, I wouldn't say, well, very hard-nosed. Because when information went to the board and things, the board is a board who said, go do due diligence. When they went to the board and told the board that, well, you have not asked about it yet, but when they told the board that it's $36 million that was paid under the LOI was paid twice. When that came to the board immediately said, we want an audited thing, do an audit of the payments made to NIDCO. So what I'm saying, that part of the, of NIDCO remain maybe true to their mission, but there are other components in NIDCO who might have been operating as enablers, unwittingly or wittingly.
Thanks for the response. Mr. George, yeah. Member Abraham.
Not to build too much on the fuzziness of what we are searching to clarify, but at this point in time, we've reached past the award. Occupation of site has happened already prior to the official permission to or clearance from. We also, a little while ago I asked you a question, how much money was paid before this? And I think you may have omitted the 36 under the LOI. But now you just told us it was paid twice, right? I want to get to something a little more fundamental at this stage of the project. Contractor OAS, which is the parent company of OAS, at the time of the preliminary works, what has been deemed as one of the world's, not Trinidad and Tobago's, but one of the world's biggest corruption cases, even at the time of the preliminary works on the highway. This was dubbed as, internationally, it was dubbed as Operation Car Wash, Mr. Chair. OAS was among several Brazilian firms accused of using Brazil's state funds, state firms, state-owned oil companies, such as Petrobras, to filter bribes to large number of public officials in exchange of bloated contracts. Brazilian prosecutors accused the firm of corruption, resulting in its loss of access to capital markets. At this stage of the project, not having spent anything close to what the total spend was, what type of red flags were going wrong or going off within the ministry, within NIDCO, and for the project AECOM, project project control manager, the AECOM, was there any type of saying, let's halt, this company is internationally being touted as not doing the right thing? They haven't gotten the claws deep into the soil yet, per se, for the project. I ask, what red flags, if any, were coming forward, and if there's any record of this?
Okay, just to point out, OAS troubles came to the fore a bit later than 2011. However, when it was said that OAS is a parent company, they were thinking of using OAS parent company to give the parent company guarantee. When that went to the board said, let's do due diligence. Due diligence was done. And it is a board that concluded that based on what we are seeing here, we don't want that company to give any parent company guarantee for the job. We want the guarantees to be standby letters of credit. All right? So that was done then. The OAS difficulties came to the fore later on when the manager or whatever, CEO was marched off to jail and what have you. So the thing hit the fan much later than 2011. But during 2011, whatever was found then, and even when OAS was being evaluated, it was said then, the evaluation report said, that that was the most litigious company in all three of them. And they listed a number of cases and things that they had. So that, that did not, that was not heavily weighted because OAS did win the thing. But to the extent that action could have been taken, the board did say to go and do a due diligence, and the board did say that we want standby letter of credit. And of course, the rest is history. We did have standby letter of credit that we were able to recall upon termination of OAS.
Right, actually, they correct me if I'm wrong, but from what has been presented, the information, we would have had 2 diligence reports being done by NIDCO.
Where's the third one? There's a third one.
Pre-award.
Yeah, where's the third one?
Yeah, pre-award.
All right. Yes, Mr. Chairman, there were at least 2 before, and there's a third one. One on May 3, 2011, and the other April 28, 2011. So that's on record.
I was coming to the question of the payments under the LOI. All right. Now, would you want to clarify when you use that term, they were paid twice, the 36 million? Just for the benefit of the members here and our listening and viewing public. No, are you looking for the minute where the board took a decision to recover the payments through subsequent payment certificates?
No, Chairman, it's more than that. I'm looking for a minute here that was recorded where the financial, well, maybe the CFO at the time had told the president that the $36 million that was paid under the LOI was paid twice, paid during the LOI period and subsequently. And afterwards, in the statement, it was said that the person is no longer employed at NIDCO, but maybe his parting information was that that had happened. No, I don't know how that is possible. Well, let me see. You come.
No, because what it does, it begs the question, payments were made against, with the exception of the $7.5 million US that was certified in-house by NIDCO, that advance payment. Every other single payment was based on IPCs issued by AECOM. Could we confirm that?
That's correct, Mr. Chairman.
Yeah. But then what you are saying that what you came across there, it would be in contradiction of the IPCs prepared by AECOM, because AECOM is the ones preparing the certificates, and in addition to that, NIDCO is also signing off on the IPCs. So after it's prepared by AECOM, NIDCO signs that IPC as well, prior to payment being made.
That's correct, Mr. Chairman.
Yeah.
And so I don't understand how it's possible.
Yeah.
I don't even understand why the $36 million was not deducted from that advance, that 20% advance payment that was made at the start of the after contract was signed, and we were paying that 20% now. It was 120. It came up to $135 million. And the curious thing is that the 135 was reduced to 128. So what was happening there? They were taking back the $7.5 million. So you paid that. You remember to take that back. But you didn't remember to take the $36 million that was expended during the LOI period. No, I don't understand. I mean, it's AECOM, it's NIDCO, and those things are not just, those are well, I mean, when you're preparing an IPC, you have levels of checks and balances, so I don't understand how that could not have happened, and people just say, well, it didn't happen.
Okay.
So
because,
I don't understand.
No, just to take it a bit further, Mr. George, if you go to page 20 of the your response, yeah, are you with me? Page 20 of the NIDCO's response to the committee for question 15, page 20 of 36. On that document, we have details of the deductions from the IPC, including the amounts and dates paid up to January 2016. Are you with me? Yes. Yeah. Now, the table that is presented here on your response, the first two items on the table, LOI reduction, IPC 01, April 2011, and LOI reduction, IPC 02, July 2011. So apparently, reductions for the LOI were actually started in April of 2011 and July of 2011. Two were done in IPC 01 and IPC 02. However, if you look at the other deduction, it is IPC 30, November 2013. So deductions were started according to this. And then the deductions were stopped for 2 years and 4 months, if I calculate the difference. And that is puzzling, because the deductions were started with IPC 1 and 2, and then it was stopped for almost 2 years and 4 months. This is in accordance with the response they have provided here. So why was it stopped? Because we started the deductions and then it was stopped.
Mr. Chairman, I don't understand why those two were made and why OAS was left with the state's money for all that time before they started back to take out the deduction in 2013. So no one could tell me that it was an oversight, that it was a deliberate, intentional thing. You allow OAS with the money. What I don't understand, I saw a payment advice, and for the likes of me, I cannot follow it, because you have the payments on the LOI. I see they have VAT. I was hoping that that the financial man here will be able to assist us, but he too is equally bemused. Right? Mr. Chairman, I really don't know. I have not been able to find a plausible explanation of that record yet. Right? It's something that I questioned yesterday and well, even before, and I'm not getting the answers.
Okay, you see, when the term we are using the term oversight, and even if you want to be generous about the term oversight, the thing is, deductions were started, and then it was stopped for 2 years and 4 months. So, I mean, we really have to be stretching it to say it was an oversight, when particularly you have two parties signing off on the IPC. You have AECOM as the engineering record, and you have NIDCO's project manager signing that certificate as well. But anyway, I think the point has been made. The point has been made regarding it. This is the LOI. Now, what I want to ask, also under the question of payments, is that, Mr. George, would you, based on everything that you have looked at and what you have presented, would you say that OS was overpaid on the project?
I would say that OAS was treated well. A lot of monies went to OAS for a number of maybe legitimate reasons that we should try to avoid as we go forward. Too much was spent on claims for not getting the site on time. And it didn't get the site on time because we were unable to deliver the sites. We didn't, the land acquisition and so was just holding up things. So they made heavy weather of that. You paid claims. And so because of that sort of delay that we were culpable for, a lot of monies were paid to OAS as a result. So OAS was paid lots of money for which we did not get productive work, right? In claims that well, a contractor can make, given the circumstances. So if we, we will need to manage that as we go forward. We must not start these jobs, as much as we like to, we must not start it too early. We must look at the land acquisition aspect of it and be able to, and do that, let the acquisition proceed for some time, before we start the actual construction work. So that was one. There's another thing where there were a lot of delays in the capping of wells, because it's greenfield construction, we're going through all sorts of oil-bearing land, and so wells had to be capped. And it is not something that OS had to do. We have to get it done through the petro train or whoever, the oil people, and that took forever. You'll make the, you'll apply to have it done, you might even pay, but to get their contractors to come and do the work, a lot of time was spent there. So yes, a lot of money was spent on them. And of course, there was this whole thing about the community protests that we are having, right? So, I mean, access to site, because of inability to deliver land, we paid about $135 million there. $50, that is. Community protests, about 26 million. Well, the other thing, well, this is what? Well, yeah, the escalation is 9. So we are looking at 160 million, 161 million paid out as a result of those two items. And, all right, in terms of overall payments made to OAS.
Yeah, under the conditions.
Under the contract now.
Under the contract.
Yes.
That's what specifically asking.
So when you're in a design build situation, well, OAS charged or claimed, their claim upfront was, was huge. Now, I'm not saying it was front-end loaded, but for the designs, you paid for that, So they got a lot of money upfront without necessarily having works. Well, maybe that's how they set up the cash flow and thing. And because you choose them, that is what you have to live with. So they get their upfront payments, yes, but it was not tied to work, as opposed to somebody else who might have gone for a smaller, in terms of the cash flow, smaller upfront payment and spread it out throughout the operation of the contract. They tend to, the pattern was to take the money upfront. And I mean that is, no, I'm not saying it was wrong, but I'm saying it's a reality. So you're paying out money, but in terms of measured work on the ground, it will take a while before you see it, and especially if. Well, if we have to terminate them as we did, then you'll have a situation where you have paid a large percentage of the contract figure, contract sum, your contract sum, that is not reflected in the percentage of work actually done.
Don't you think that the procurement model that was used, a design-build model, actually gives that, a model inculcates that degree of risk? Because, in terms of the design element, the preliminary designs, detailed designs, all of those things, that would be predominant in the early stages as compared to works on the ground, because the works on the ground will just be probably site clearing and mobilization and those things. So because of the procurement model itself, you have an inherent risk in that direction.
I I don't want to be too cute in my answer. I'll probably say all models have risks, Mr. Chairman. And you just have to know what the risks are and try to mitigate them as you go forward. So I will not blame it on the model as to maybe blame it on our lack of, well, no, I would just say that, Mr. Chairman.
All right. Let me come back to the payments under the LOI, I think which amounted to 36 million US dollars. Now, on page 18 of the responses that you give, responses to objectives 1 to 4, volume 1 of 2. Page 18 of your response, the response from NIDCO. There's a table that is presented there in terms of response to question 11, where the question is provide a detailed breakdown of how the US 50 million was spent by OS. And you have given quite a detailed response there. And this is under the letter of intent. Under the heading campsite, 5.7 million US dollars. Engineering designs, 9.5 million US. This is the actual expenditure that NIDCO paid for. Negotiation with suppliers, 8.7 million. Financial and schemes bonds, 3.375 million US dollars. Indirect costs, 9.68 million US dollars. Totaling 36,938,000 US dollars. Now, I think the intention within the 90-day period, and from what I gathered from the documentation, there was an urgency to get the project going. So this came about because the 90-day period was really to facilitate the government putting in place the financing arrangements. And at one time, they had requested NIDCO to do that on their behalf. So a situation was that this 90 days, I don't know how that was arrived at, that it is so important to start this project that we could not have waited 90 days. You had to get everything moving, even to the point of bringing in a letter of intent and all of those things, when already the conditions of contract and everything were worked out. And my question, well, one of the questions is that with this 36 million expenditure here, did we get value for money to start with? Because that is one of the objectives of the inquiry, to ascertain whether we did get value for money. And whether or not the intended, that was put forward to NIDCO's board through its tender committee, that the project was urgently needed, the start of the project was urgently needed to provide employment and stimulate the economy and things like that. It's mentioned here in the documentation. Whether that was really achieved by this expenditure. Because looking at the categories here, I'm not sure how much of it actually would have filtered down to persons being employed on the ground. As you earlier mentioned, measured works, because I interpret the campsite as temporary works, okay? Not permanent works under the contract. So this was for temporary works. And also, if you could provide some clarification on the indirect costs that total $9.7 million US.
Right. Mr. Chairman, we have attached, with the LOI, a very detailed work breakdown structure that was drawn up. Now, ACOM is at the party now. Drawn up between ACOM and OAS. very detailed work breakdown structure. So in terms of value for money, as long as those sums that were spent there will be part of, let's say, the prelims that we'll normally have on, you know, in a contract. So as long as you sort of take that on board with the main contract, you know, after you have executed the contract, then you have not, how should I say, wasted anything, because he would have had that in his prelims, works that he had to do. If we had to do that now, what we will do, we will ask him, give him that, confirm, we could even give him a letter of award. But anyhow, if we can't give him the letter of award, so we know Cabinet has approved, but funding is not in place, we could bide some time. We could even ask him to ensure that the validity of this, his tender period, if it has expired, we could ask him to extend it. And if he knows that he's on the brink of getting a job, he will just extend it, and he'll wait with us. So I didn't see the dire need to sort of start when they started, and to have the complication of the LOI on our backs today, you know. But, it is possible that you could have done it differently, and he could have waited that 3 months or whatever you say. But I know, and that is why I say, those things have risk, but it's how you mitigate risk. We, the government, Trinidad and Tobago, we were quite prepared to enter into an agreement with him and tell him, listen, even if at the end of the 90-day period, if we are not successful, we will pay you $50 million, right? So that is how willy-nilly we were with the disbursement of funds and things. So, so what if, because I might add, we are not very, when we went out to get the loan, how successful were we? A lot of people, went out to a lot of people. When it came back, 9 people came back. 9 people came back? All right, and it was about 20-something we went out to. So, you're going out for a loan. There is no guarantee that you won't get it. But we are so positive that we are prepared to tell the contractor, hey, go on and start. All right? Do things, do your designs or whatever. Do that. And whatever expenses you incur as a result of doing things to advance the start of the thing, we're going to pay you for it. And if at the end of the period we can't get the finances, we're going to we'll just cap everything at $50 million. And the same document says, well, we start with 90 days, but it could go to any other time that we can both agree. So what's the urgency? I didn't know. And I can't see anything in the record to suggest that you had to start when we started.
Thank you for that. Mr. George, in terms of the indirect cost for the 9.7 million, you all have provided, I know one of the IPCs, one of the appendix have a listing of all the interim payment certificates, but I think, correct me if I'm wrong, but Mr. Richard, the details of the payment evaluation is not there. It's just the summary page that we have, the certificate. But in terms of what that payment covered, is that somewhere in the documentation?
The details of this.
And those are the extent of documents that were provided by the engineer. These are.
But would it be normal practice when you do get a certificate for payment? Mr. Ramsing is here with us as well, very experienced. That there would be the backup to go with it, to whether it's measurements or invoices, payments made, and all of those things. So that And so you could actually justify the figures that is there on the certificate. Because indirect cost of 9.7 million US dollars, it raises questions, you know. Not that it was made in a vacuum. I'm sure there would have been justification for it, but the committee would have really liked to see information that explains this indirect cost. And then if I go back to negotiation with suppliers, 8.7 million US dollars for cement, asphalt, aggregate, and steel. Does that represent actual down payments that were made to the suppliers for which the contractor was reimbursed?
Well, that will make sense, Mr. Chairman. If one gets, or when one gets advance payment, it is prudent to use that advance payment to sort of lock in your price because you have price risk and so. So if you could go to the cement supplier, let's say cement or concrete supplier, say you have a certain volume of concrete for the job, and you say, hey, I'm going to pay you upfront X dollars now. And that in return, you're going to maintain my price, the price to me for concrete for this project. The concrete supplier is likely to say yes because he's getting that upfront payment. So you could use, same thing with the steel supplier, So I take it to mean that, they went to the various suppliers and they were able to maybe lock in their price for some period of time, maybe the first year, because thereafter they could have gone for escalation. But, so that is where that would have come from, which is a normal thing you do with them, which is a prudent thing to do with upfront payments.
No, I appreciate the response. I know that is the practice that obtains in the industry, but it's just that, if the figure is being certified, I'm just saying, what is the backup information that came with it to say, well, look, X dollars was paid to TCL or whosoever it may have been, and seeing that the employer is actually paying for it, what sort of guarantees there are that would secure that payment in case anything goes wrong. Does the employer have redress, in terms of that particular supplier that monies were paid to? So it's a range of stuff, But it is just that we are seeing the summary of the IPC, the certificate, the sheet that comes, and all the backup that goes with it. It's not there. So it's difficult for us to really assess,
Mr. Chairman, we will try and locate whatever backups exist and we'll make them available to the committee.
Okay, thank you. Yeah. Okay. No. Okay, Member Saga Sukla.
I just have thank you, Chair. I just have some general value for money questions to pose to, of course, any member of the committee that appears before us. It's my recollection, based on the reading of, all of the submissions, that there was a ministerial oversight committee. Can you just, at least for the benefit of the listening and viewing public, based on your records, identify what were the role and responsibilities at the time of that ministerial oversight committee?
Mrs. Yearwood, Francis Yearwood, you could come in at this time.
So, member, I'm seeing details in regard to the tender evaluation committee, which was multidisciplinary, as well as the negotiation team, which was multidisciplinary. I'm not really seeing a ministerial or interministerial oversight committee, but I would check our records and I will provide whatever can be found.
Because there were actually some questions that I had relative to that specific. What I would do is, Chair, of course, through you, I would just make when we return, I would just go through my brief and just point the members directly to where I would have read that in the submissions, and probably that could be the springboard, you know, for this line of. On page 3 of your response to request for additional information, so that's the new information that we would have been provided with after the first hearing. The response to question 6, which was asked, was to provide a list of the members of the tenders committee and board of management who served at the time of the LOI. And on page 3, it read as follows: the members of the tenders committee at the time of the execution of the letter of intent of March 4th, 2011 were as follows: Professor Winston Sweet, Director Chairman, Mr. Rabindra Autar, Director, Mr. Carson Charles, President, Mr. Michael Gayadine, Vice President, Finance, Mr. Dinanath Ramkisoon, Vice President, Legal, and Ms. Hilda Gudial, I think, Corporate Secretary. First question, at any point in time did the tenders committee carry out, would you know whether or not they carry, I know we have the due diligence reports, but do you know specifically if at any time the tenders committee carried out due diligence by seeking legal advice about OAS? And in light of questions posed earlier on by member Ibrahim, based on information that was happening internationally, information that you would have indicated also came to NIDCO about OAS. Do you know if that tenders committee at any point in time, if there's any written information or any legal opinion at all that they may have sought about OAS, legal advice on OAS?
Mr. Chairman, well, there's nothing on record that says the tender committee requested. What we can say is that, as we made reference earlier, there were 2 due diligence reports that we have that, it was requested. Well, tenders committee, as I said, they don't make this decision, they make a recommendation. That goes to the board, and the board, coming out of maybe information that they had, they requested a due diligence. So I'm saying due diligence was done, but not necessarily called for by
legal advice.
Yeah.
Okay, so then let me refer to the due diligence report, Appendix 9.1, written by Mayor and Company and dated May 3rd, 2011, which highlighted concerns about OAS financial stability. Now, this report highlighted the number of claims and proceedings against OAS, amongst others, which place OAS into ranking in terms of priority. And this is, of course, as I said before, it's in the due diligence report, Appendix 9.1. So my first question, based on that report, to what extent was this due diligence report considered by the board? Do you have any? So there is the report. Is there any evidence of the extent to which this report, of course, was considered by the board?
Mr. Chairman, as I indicated earlier, that report would have fed into the decision to move towards standby letter of credit as the instrument to sort of secure the performance bond and other things, right? So they move from whatever else that could have been used and whatever else is used in the industry to standby letters of credit. And that is fairly rigid and easy to access in the event the company fails to perform the activity that they are contracted to. So I'm saying that would have influenced that decision.
So I accept the submission, but I'm wondering also, wasn't this report not enough, perhaps for the Vice President of Legal Services, Mr. Dinanath Ramkisoon, to whom the report was addressed, to perhaps even alert the Tenders Committee of the standing of OAS, or you believe that the submissions that you made, that perhaps this was indeed brought to the attention, and as a consequence, we would have had this position?
Well, Mr. Chairman, I would just say that maybe proper use was made of the information that they had. They might not have routed it as the member is suggesting, but it went to the company, and the company used it for what it's worth, and they used it, in the context of what their risk appetite was, so they could have, dealt with it, and then they say, okay, give me standby letter of credit. Mr. Chairman, if I may, at long last, I have found that reference. So, and the reference I'm talking about is where the payment was made twice. So it is in board minute number 80. I'm not too sure whether you have that, but if you do not,
no, I haven't come across it.
Right.
Yeah.
And under 5.8.2, it is reported as follows. The chairman informed the board that he was advised by Mr. Michael Gayadine, former Vice President Finance, about an overpayment made to OAS Contractor in the sum of approximately US $36 million. Mr. Gayadine has since left the company. That is the $36 million that was paid then.
Okay, but acknowledge what you have said, but how, in terms of that particular statement by Mr. Gayadine, and based on all the discussions we have had regarding certification and all those things, how do you reconcile that statement?
Well, I'm uneasy to have read that in the first place.
Yeah. No, that would definitely raise many red flags.
Yes, yes.
But, that statement being made against, actual certifications, actual payments made, through NIDCO, you would have all your records and all your accounting records and everything. Could we marry that statement with what payments actually made?
All right. Here is how it could have happened, Mr. Chairman. So under the LOI, I set up my offices. So let's say I have offices, and other thing came up to $36 million. When I submitted my claim now for payment, well, remember you have paid that money and that money is out there. When I now submit my claim for payment, my claim for, let's say, my contractual payments,
contract,
right?
Yeah.
So let's say under the first claim that I set up, I have, let's say, the same items, and I have these sums of money there. And nobody saw it at the time to back it out and say, but wait, now we pay for that already. So they have it in there, and you pay for it again. but you paid for it earlier. And that is why you had to take back that money when you gave the 20%. But you didn't take it back, you left that out there. And now you come and you incorporating the items of works that you paid for under that in his claim now under the works done, right?
Okay.
And you're paying him again.
All
So
right.
that's where this guy is, that's
Yeah,
where the
okay.
twice payment.
But then subsequent to all that and the discovery of that, the board of NIDCO did come up or did look at recovering the monies through deductions, through LOI deductions in subsequent IPCs.
That is correct, Mr. Chairman. Yes, it would have been recovered, but
No, the advantage of the cash flow.
It's 2013.
Yeah. The advantage of the contractor having that money is, of course, is a definitive advantage, right?
Precisely. Yes, Mr. Chairman.
And at the time of the termination of the contract, the full amount wasn't recovered at that time. And that is why the negative IPC was done, in order to come now and reflect all these matters that came up.
That's correct, Mr. Chairman.
So before we close for lunch, I just want to all of us to just look at the question of the negative IPC. Right, that is the last interim payment certificate that was done by AECOM. And that negative IPC, what was the main outcome of that negative IPC? It was to address to make sure that the full deduction for the LOI payment was recovered, and what other factors were taken into consideration there? Because it would suggest overpayment on other aspects of the contract, would it?
Mr. Chairman, I guess the question is, how does a negative IPC arise?
Yeah.
In that case, the contractor had done some work. So I think, Golconda towards the bay, I think. And there was a drain, a median drain or something that had to be lined, concrete lined or whatever. The contractor did not do that item of work. But when he submitted his claim, he was paid for that item of work, which can happen.
Yeah.
The engineer now, on discovering that, will then instruct the contractor to sort of make good the omission. So go do the work. The contractor gets that directive, but fails to do the work. And if that goes on for a period of time, FIDIC allows allows the engineer to decide, well, to do the work, to make other arrangements to do the work, and to deduct a sum of money from the contract sum to pay for those works. So let's say they determine, well, okay, that will cost you $500,000, and you have not been doing it. So it is as though you have $500,000 that you ain't supposed to have. I will now take that $500,000 back from you because you're not making good that item that you're supposed to. So it was, it is things like that. Plus, of course, the recovery of the advance payment done under the LOI. So you had some monies there to recover. So all of that will be added, and at the end of the day, you will have this grand total. I think it started at 55, But okay, so you have these monies there that you owe the state that you have not paid. But then you have IPCs that you continue to send. And you continue to feel, well, okay, you send me an IPC for $20 million, and I must pay the $20 million. Even though the negative IPCs that you have, it might be $21 million. So this is an area that, well, enters the new board. And the new board says, but no, that can't happen. Let us apply the negative IPCs. And I was being told, well, the board was being told at the time, well, if you do that, you're going to kill the contractor. He will not be able to do the work because it depends on that, let's say, $21 million that all you have for him. And now you're going and apply IPC, they'll go wipe off the 21. So where you get the money from? You know, that kind of, that was the argument that was given to the board. The board was not persuaded that they ought to just allow this contractor to have the funds, you know, because, I mean, all along, and you've seen all along where we're just bending over backwards and facilitating this contractor. So how are you now telling me that I cannot apply that negative IPC, allow the monies to go to the contractor so he could do and finish the work? And, well, my thing is, how do you know you're going to finish the work? And in fact, he could have never finished it. Well, that was our assessment, and there's nothing that has happened to change that so far.
But who it is was telling the board that?
Who was telling me about that?
Who was telling the board, don't apply the negative IPC?
I got a recommendation from the engineer. That's a FIDIC engineer.
Okay.
You know, so they're close to the ground. They're saying, but if you do that, this man wouldn't have any money. You know, and well, I refuse to be guided by that, and I felt the negative IPC should have been applied as it was.
One possible option would have been to have it reduced on an installment basis. If the engineer is saying, well, if you grab everything away from him, it would shut down the project. You know, we could have said, okay, we take it out in the next 6 IPCs or whatever it may be.
But at that time, we're talking about 2015,
Yeah.
and he had done precious little.
Yeah.
After the March 2015, when things got very, you know, when people start to go to jail and things, he showed a continued inability, you know, an increasing inability to engage the work. So what he was doing, he was just marking time and trying to pay contractors that he had owed. He was owing people about $47 million, about 300 and something of them, local contractors that he was owing $47 million. So everything that he was trying to do is to get monies to be able to pay down that debt. So even when he was coming to us and seeking monies, it was not to plow back into the job and increase production, but it was more or less to pay down his debts, right? And well, that followed 2016 when he demobilized for the end of year break in 2015, and he did not come back to site. And of course, well, all sorts of negative things started to flow.
All right, well, one final question before we break for lunch. But you think the engineer would have been comfortable with the fact that there was the performance security to address such a recommendation of not applying the negative IPC, you know, allow the contractor to continue, probably in their opinion, in the best interest of the project. But knowing that I have performance security to cover that risk?
Well, that did not pan out, Mr. Chairman. You know, it's just time. Time is going, and nothing is happening. And the contractor himself is saying that. So you're saying they're not producing. You're saying that they have lost the will or ability to work. And they themselves came to you and said, well, you know, we could still do some work, but you'll have to scale down our scope. And that gave rise to what? Addendum 2. So you couldn't finish the thing. Well, so what the engineer was telling us, that had no substance, because we were in the era, in the age of Addendum 2, where the man is admitting to us that he can't do the work. He doesn't have the wherewithal to do the work. However, he could still do some work. So you're going to scale down his scope, and we went along. That's why we had addendum 2. And then they said, okay, we're going to get local contractors and we're going to go into contract with them and novate them to you. And here what to do now. A local contractor now will have to give a performance bond for the work that he's going to be doing. So he says, that is OAS says, well, okay, you can have performance bond from, let's say, these local contractors here, who will now do your work. So reduce my performance bond security by the amount that you get in there. Right? So if I had performance bond, if we had standby letter of credit holding for 40 million US dollars, and you will be having, right? We talk about construction risk. I know that is it. That is what is steering us now. We now have contractors here who will give you bonds for their performance. So you'll be protected. So I must now, take that money that I have holding, $47 million, reduce it to about 20. So I'm now holding 20 plus what I'll get from those local contractors here. And my contractor that I contracted the job with, he can just take that and hightail it back home because he has lost the ability to do the work. And we are about to facilitate that.
All right, so it's a good point. If we can suspend the meeting for lunch. And thanks, everyone. And we would resume at 1:30 p.m. So, hearing is adjourned. Good afternoon once again. I'd like to reconvene this meeting regarding the second public hearing pursuant to our inquiry into the 2023 NIDCO report on the Sir Solomon Hochoy Highway Extension 2.14 project. And this session, we will be looking at, in particular, we start with the questions concerning Addendum 1 to the contract with OAS. So I'll ask our member, Dinobrica, to lead us off.
Thank you, Chairman, and through you, good afternoon again, everyone. Chairman George, I am starting to feel a bit sympathetic towards you because it seems that you are carrying most of the load today again. So I don't know if Ministry of Works can add value in this conversation, but I suspect that yet again it will really be a NIDCO-led conversation. Chairman George, from the conversation that we started in the last session through today where we have touched on it, I have to admit that I continue to be extremely confused about Addendum 1. The genesis for it, its necessity, and everything that stemmed from its introduction in April of 2013. If I can get us, if you can correct me on the summary, and I can ask you to expound a bit on it. The section of highway, or the road section from Dumfries Road to Parrier Suites, was part of the original scope of the project, correct?
Yes, Mr. Chairman, but it was removed by Addendum number 1 that went out to tenderers. Not Addendum. Yes. Yeah, Addendum 1.
Not this one.
Well, this is also called Addendum 1.
Correct.
No,
So
that's why I say that went out to tenderers.
Right. Yeah. So it was part of the original scope. It was removed from that scope at the point of tendering. Yes?
That's correct, Mr. Chairman.
Then during negotiations, it formed no part of the project that was being negotiated with OAS. Is that correct?
Mr. Chairman, during negotiation, it was reintroduced now. They wanted it to be part. And more than that, they said that, okay, it's going to be part. The funding of it, the payment for that, will come from the value engineering exercise to be conducted over the entire project.
Right.
So the value engineering will generate savings, and from that now, we're going to be able to fund those works.
So
Very
that would have been,
optimistic, and that did not pan out.
and that would have been at the negotiation stage before a contract was signed with OAS. Correct.
That's correct.
Right.
Just before you go on, as we are on the point, just to clarify as well, on page 6 of the report that was submitted by the negotiation committee, Mr. George, on page 6, in addition to what you just outlined there, that section of works would be funded by the value engineering exercise under the contract. It further states, and this is the negotiation committee's report, so Member Dinobrica, just to note that it further states in the last sentence of under point 5, under commercial and legal issues, that NIDCO and OAS further agreed that this portion of the work is to be completed within the price at no extra cost in NIDCO, regardless of the success of the value engineering. So I just thought, as we are on the point, it was not just a question of the value engineering.
Yes.
Irregardless of the success of the value engineering, it was deemed to be included in the contract.
All I can say, Mr. Chairman, that was just a feel-good statement because it is stated there, it is stated elsewhere. And when we look at Addendum 1, you will now see that the contractor is saying, hey, I can't find any money. You'll have to pay for it. And then we turn around and say, okay, we'll give you $17 million out of the 32 million. So which one is correct? Anyhow.
So I think that was, remember, the noble girl was getting.
Correct. So it is in, it is out, it is back in, and then it is back out again. So I'll tell you what baffles me in this, Mr. Chairman. And I am not trying to come to, I'm trying my best because of what this exercise should be. I'm trying my best to not arrive at a position before I've gone through the process. But I can't understand how a contractor will agree to do something basically at no additional cost, something as significant. I could understand if there are minor components to a project and the contractor out of some sort of corporate governance, you know, that there is maybe a qualitative component to your project, or you do something in a community. I can understand all of those things. But to do something that is tens, $100 million worth of work in a project, and by that, well, maybe I'm jumping ahead too far, but to agree to do something at absolutely no cost to the contractor, and then I have to agree with you. I also don't know how, Chairman, how you value engineer $100 million out or into a project. So in April of 2013, OAS and NIDCO enter into an agreement to reimpose this section of road and whatnot back into the project. And of course, well, to the best of my knowledge, nothing ever comes of it. So you've reintroduced the road section of Dumfries Road. And here is where I think I get a little confused. It says that the employer would pay the contractor an additional sum of $108 million, exclusive of VAT, from the provisional sum included in the contract. And that payment for the additional sum would settle various outstanding claims made by OAS. And those claims made or to be presented for any event occurring on or before August 30th, 2012. So can you tell us, for the benefit, well, not just for our own elucidation, because this really has been a confusing 2 sessions, but also for the benefit of those listening, what the work that was agreed to in Addendum number 1, how much of that work was actually done? How much of that work was actually done by OAS after entering into contract Addendum number 1?
Addendum 1, the work was actually done by OAS. That is to say, the work described, that is the section of road from Dumfries Road to Barrier Suites. You know, so that was in the scope, it was done by them. They told us in Addendum 1, item H, I think it is. Yes, it says, the employer has agreed to share the aforementioned cost of work, package 2A, and package 2A is that work that we're talking about, to the amount of 108 million VAT exclusive. Well, that's about 17 million, right? 17 million US dollars. In consideration of, in consideration of the contractor. So, you're telling us that the contractor is going to do the job, do the work regardless. That's what you will have us believe. And now you are executing Addendum 1, and you're saying now that you're going to share the costs. So you're putting $17 million there. And it is in respect of the work that you say that they're going to do at no cost. That's why I said just now that it was just a feel-good statement. It didn't happen. and more importantly, you said that you're going to put in $17 million. He's going to do those works that, where the contractor has reported that it will cost $32 million. He's getting $17 million to do it. And you'll have us believe that the $17 million is your little piece you're putting in to do those works, plus the fact that he's going to waive those claims that he has. You'll waive in all claims and notices existed and submitted and so on, so on, so. When we go to an AECOM assessment of the claim, where they just total the claims that is being referred to here, AECOM is reporting that the total financial value of the claims, claim notices, and delay costs equals approximately US $159 million US dollars. So who is fooling whom? How will a contractor legitimately, well, maybe those claims were not legitimate in the first place, but he has claims on the table, value at $159 million US. He tells you the work that you're asking him to do, he can't do it because he didn't find value engineering. And the cost of that will be $32 million. So let's add those things up together. So how could you just get $17 million and you go away hopping, skipping, and jumping, and you're happy because your employer has now given you $17 million. So you could waive the claims that you had, valued at 159, and you're going to waive that portion of the money that they should have given you because they only give you $17 million. You had asked for 32. So these things make absolutely no sense. And, I mean, it strains credibility. It makes no sense. But that is what they'll have us believe.
Yeah, Mr. George, the contractor's claim at that point in time was, you said, 159 million US dollars, right? Yeah, the sum total, approximately.
It's 159 million US dollars. Yes, right. Mr. Chairman.
Did AECOM ever did an assessment of those claims? And if they did, what was their recommendation? An assessment of the claim based on the conditions of contract, and as to what they did a report as to what the employer's liability may be with regards to the claims.
I have not seen the assessment, Mr. Chairman. AECOM will probably tell us that, well, of course, the claims were waived, so they didn't have to consider those claims to assess them. But the same AECOM is reporting that the claims that we have, that's the value that the contractor is claiming. They are not saying that, okay, we have assessed the claim and the contractor is entitled to 159. AECOM is telling us you know, enabling the narrative of this Addendum 1, you know. So there are enablers all over. So ACOM is telling us that, okay, the contractor had $159 million of claim on the table. And that is what he's waiving.
All right, but I mean, if I'm going to a negotiation table, say just for instance, and just from a point of view of just plain logics, you know, logistics, logical thinking. If a contractor is using 159 million US dollars as a negotiating chip, to say, look, I have all these claims here, and I'm looking to get this from you, and your engineer is there. You know, would it be logical thinking that to ask the engineer, what is your assessment of this claim? So that in reality, when you sit to negotiate, you know the reality of the claim, not the contractor's 159 million, but you know, if you assess it against the contract, maybe it's 10 million, maybe it's 20 million. So you know exactly what you're negotiating with, or what you're negotiating away.
That is very reasonable, Mr. Chairman, except that I've not seen where that sort of exercise was done. And the only thing that I found was that letter from which I quoted.
Okay. And the $207 million that OAS came up for that the Dumfries Road to Paria Suites, that section of the work. Was that measured against an engineer's estimate during the negotiations?
Oh, sorry. Mr. Chairman, while it was being negotiated, they asked OAS to submit, is it comparative quotation from contractors? Because OAS was saying that the value of those works was $13 million. The comparative, ACOM was saying it's 13. OAS is saying it's 32. OAS went out. Well, could I have it? All right, thanks. Where is the? So yes, the engineer's estimate is 13 million. The contractors is 32. Three contractors ranging from, so the three contractors that they ask for, 26.1 million, range from there as a low, and 33.6 million. So it seems to me that the contractors, they were saying that it's around $32 million. OAS was saying that the engineer's estimate was 13 million. And the client, or the employer, decided to give $17 million as part of his contribution.
All right, but I think I came across somewhere in the documentation and your responses that AECOM estimate for that piece of work originally was actually $12 million US.
Okay, Mr. Chairman, well, if I said so, then 12 is wrong. It's supposed to be 13, because this document here is taken from, taken from a letter on the 10th of July from AECOM. Right, so that is fairly accurate then, or is a more accurate figure.
Okay, thanks for the clarification. In addition to the question of the value of the estimated value of the works for that work package 2A, what is referred to as 2A, I think the settlement of the Addendum 1 also speaks about, by virtue of Schedule 2, this is item B of the contract addendum, time for access to site. The parties agree that the sites listed therein would be made available by employer to the contractor on the dates listed in the said schedule. And it goes on point C to say that the employer did not provide to the contractor full access to the sites in accordance with Schedule 2 of the prime contract. And the failure of the employer to provide full access to the sites as required by Schedule 2 caused the contractor to incur additional costs and delays. And I think earlier on, you did attribute this to one, the delays in the land acquisition, and you did mention the capping of the wells by Petrochin. So I think at this point, I would like to bring in Member Morris Julia, because she has some questions to lead us off with regards to the land acquisition.
Thank you very much, Chairman. Chairman, through you, I'm very happy to see the Director of Highways here, because I really want a question for listening and viewing public, and of course to myself, because I own absolutely nothing. Could you let us know what is the process of land acquisition? Let's just say, I would use my area as an example. There's a road that needs to pass through privately owned lands, state-owned lands that may have residents there for a very long time. What is the process? If you could just take us through that particular process, because I would really like to do a little brief compare and contrast.
Good afternoon, Chair. Through you. I'll start and then I'll ask our legal officer to come in and give us some more salient details, right? Once a project has been identified and declared as requiring lands for a public purpose, the Land Acquisition Act comes in force, and there are various steps under the Land Acquisition Act. There are various options for the acquisition, either by private treaty or compulsory acquisition. Right, so I'll ask Mr. Gajada probably just to take us through briefly the steps involved in the options.
Hi, pleasant afternoon. All Chair, through you. The Land Acquisition Act, Chapter 58, sorry. Yeah. Sorry, ma'am. 5801 allows for the state to acquire lands, and in particular, if it's for the construction of a road or any associated infrastructure for a road, allows the permanent secretary to acquire those lands. The correct procedure would be, after Cabinet would have approved the general policy and the project, it comes to the ministry, and we would first do a Section 3 in accordance with the Land Acquisition Act. This allows the state to enter into the lands to do superficial investigations, the topographical survey, make sure that if just soil analysis needs to be done, and basically map out the proposed roadway or project onto the land. After Section 3 is done according to the Act, the next step progressively would be a Section 5.1 or 5.1, which is declaring the land for public purpose by the President. Then there's done a 5.2, which is normally we would write to Cabinet, and eventually a 5.3 notice would be done, which is a negative resolution of Parliament. However, if the land is urgently needed for a particular purpose, there's Section 4 allows for us to take the lands prior to it being formally vested under 5.1. It allows the permanent secretary to take immediate access to the lands. Under 4, the Land Acquisition Act has the procedures prescribed under 5.3, must be published in a daily newspapers twice, must be gazetted. Those would pertain to the Section 3 notice and the Section 4 orders. Compulsory acquisition is is the modality in which we would acquire any land by the state. Once the land has been acquired, there's a formality of we serve your notice, then we will serve the order and enter. You are required to engage the services of a registered private valuator. We would send you the list of registered valuators in Trinidad and Tobago. You would submit your claim to the ministry, your private valuator's claim, and we would now submit it to the Commissioner of Valuation, Ministry of Finance, who is the sole authorized person to negotiate any compensation on behalf of the state. Once that compensation is negotiated, if the cabinet minute prescribed that we must go back to cabinet to seek permission to make payment, then it is done. That is generally the general operation of the Land Acquisition Act. Thank you.
Thank you very much for that very comprehensive yet brief summary. But here's what's puzzling me, and through you again, Mr. Chairman. I remember newspaper headlines. That's how my brain operates, right? And around this particular time period, there were outrage, protests with the landowners, etc. So what I'm curious about was this particular, I would assume that I was given the correct way in order to do this. Was this done for the Point Fortin project prior? So that's my question before I go into the other questions. Did they follow this particular protocol and process?
Chair, through you, as far as the records of the ministry to which I had the opportunity to peruse, I would have noted a Section 3 was published, a Section 3 notice. I would have noted a Section 4 order was subsequently published, and I would have seen valuations being submitted to the ministry and transmitted to the Commissioner of State Lands. And that would have been for my limited period at the ministry. So I can only speak from what I would have perused from the records of the ministry.
Thank you very much. Through you, Chairman, to the Chairman of NIDCO. I mean, $500 million and was paid to homeowners to acquire the land for the highway extension. And that is not any small sum of money, right? Were the written guidelines established for the relocation and the compensation of the affected persons?
Yes, Mr. Chairman, the guidelines were there. Now, we followed what was outlined previously. There is one caveat. It was private treaty done under the shadow of compulsory land acquisition. What that meant was that you do the social survey, so you know who is on the property, you know who the owner is, and I'm talking about a building and property now. You know who the owner is, and so you know who you have to talk with. In addition, well, that is after having published your Section 3. You're able to enter the property now to do your surveys and to determine what your land take is going to be. And having done that, NIDCO had a team of, a team consisting of legal people, valuators and so, and what else? So those persons now, they will engage the process of determining, but before that happens, they went back to a land acquisition body at NIDCO to give the particulars of the property and to get an idea as to what will be the value, what is the opening value that they can start with. And that is where the private treaty thing comes in. So that committee will tell the team, okay, you can offer them X thousand dollars for the property. They will then go back now to the owner and they will start the negotiation. They will probably negotiate and the owner might agree, or there might be some movement and eventually meeting of the mind. So they will take that value now and go to the tenders committee we have? Yeah, NIDCO's tenders committee, and sort of submit the agreement that they have struck up with that person. If the property, and then the tender committee will generally approve it, and they will send it on to an interministerial committee set up
Just
to
one
review.
second. That's not to interrupt you. I wanted to continue on that way through your chairman. Interministerial committee.
Yeah.
Okay, that's interesting. Thanks.
Consisting of representatives from the Ministry of Works and Infrastructure, the Ministry of Housing, Land and Marine Affairs, the Ministry of Finance and the Economy, and the Internal Valuation Unit of NIDCO. So that team will look at the value and usually they'll approve. So once they approve, that payment is made to the person, and you can not just take possession, because the law allows you to. After you do Section 3, you do Section 4, you could take possession, but you have a happy campaigner now that there has been an agreement, they have been paid for the property, so now they can move on. But even then, they take some time to vacate the premises. So even after you have gone through that, you might find that you still have to give them a sweetener to move them. So then we had situations where people have been paid, but they're not ready to move yet, or they have nowhere to go yet. So what was done, they were given, in some cases, 6 months of rental, 6 months of rent, so they could rent a property and move on quickly. So we had that as a sweetener. We also helped to move them. So those things came in, and we are saying that all of that was done under this private treaty business. So at the end of the day, you got the people, you got the agreement, you paid them, and you went through the difficulty in sort of moving them to get free possession of the property that you had acquired.
Through you, Chair. So let me get this right. They were compensated, and then they were compensated again? Or, well, you're saying sweetener, but I mean, it will be a lump sum of money to rent, or, right? And I'm also reading that some persons may have received HSC allocations. So if I receive a HSC allocation, was I also financially compensated for this move?
Mr. Chairman, NIDCO also got Cabinet Minute 1958, July 18, 2013. And in there, we had an agreement that Cabinet made to offer residents in, let's say, Pitimon. There were 80 such residents. Pitimon. Granted residential lease in respect of a parcel of land comprising approximately, so those persons were granted leases for land in Pitimon, people that you would have acquired the properties from, for a 99-year period, and for $50,000 and an annual peppercorn rent of $10. They had also provisions for squatters on Cedar Hill, and so that's Pitimon and Cedar Hill. the problem was that, so yes, you have paid them for their property, but they're saying that they have nowhere to go. And if you look at the World Bank policy, is that where you're doing those kinds of mass relocation of people or movement of people, you have to treat in such a way that they are not disadvantaged. Well, I mean, you could give them the money, but they may not have any way to go. Or the money that they get in, they may not even be able to buy something to establish themselves. So that's why the government comes in afterwards and maybe create areas that they can move into. They were even supposed to sell those properties at some low rate. Now, one is not sure whether the money was ever collected, but that is how it is. So after you do all of that, sometimes they're just waiting on the properties that they have been offered to be available so that they can move to those properties. And that is where you had further delays, because in some cases, the properties had to be developed and they were not developed. So they were waiting on the properties to be developed and ready and handed over so that they can move. So that's where the rental thing came in.
So to be developed, excuse me, Chairman, developed by the government for them?
That's correct, Mr. Chairman. Yeah.
Okay. The evaluation process for the assessment, payment of compensation for lands, for the construction of the entire project. Can I please, I'm not sure who would answer, Chairman. I just want somebody to go through how did they come to whatever figure and who was the authority that agreed to the figure?
Okay. Mr. Chairman, the teams that we had, they were staffed with valuers. Valuers, well, not just recommended, but approved by COV.
Mm-hmm.
They will generally handle the smaller properties, but there are some large properties as well. Those large properties will be referred to the COV for the COV's determination. But if you have a house on a 4,000 square foot of land, the valuers embedded in the various team or assigned to the various team, and with the approval of COV, they could do that valuation, right? So we had that system in place, and that is what we were following.
Through you, Chair. So, for example, the evaluator says would $25, right? And am I to go along with the premise that that $25 would be accepted by everyone and go on, or were there ever any increases or decreases?
No, Mr. Chairman, they don't just accept it because you say, because they will also have a value working for them.
Right.
Right? So they have the value, we have a value, and then the people come together. So we might start with, we might say 25, but the valuer might say, no, 25 is not enough, and then there is a to-in and fro-in, and eventually they'll come to some agreement.
Chairman, I just have one last question, and then I will give way to my colleague who is also interested in the land acquisition process. Through you, Chair, it seems like a simple question, but this entire inquiry has been an eye-opening experience to my colleagues and myself. I really just want to know, what were the steps taken to ensure the integrity of the land valuation exercise?
What were the steps? Except to COV satisfying itself that the valuer who is engaged in the exercise is competent and respected. No other step, as far as I know, was taken.
Okay, before we go to Member Sagram Singh Suklal, just one or two general questions regarding the land acquisition. In terms of the utilization of the instrument of private treaty that was given to NIDCO, were there any precedents for such an instrument being used by government or agencies otherwise for land acquisition outside of what was outlined by Mr. Mohan Singh? Mr. Edward, are you aware of that instrument being used on any project before?
Mr. Chairman, I'm not aware. I'm not aware.
All right. So we had the creation of this instrument by for the with the obvious intention of accelerating the acquisition process. I would think that would have been the primary objective. And would we consider it in terms of, did it really solve anything in terms of that objective? Did it get us closer to that objective in any way? Bearing in mind that the sites were still not delivered to the contractor on time.
Well, Mr. Chairman, there was considerable delays, notwithstanding the objectives that we went into the exercise with. There were delays. And I know you had delays, well, the sites were not ready. You had delays even where people are not accepting or they are moving on and, you know, with their lives going elsewhere, someplace that they have created or found. They use the opportunity to, you know, so some of them, they use that rental thing to the hilt. I mean, it went from 6 months to maybe a year in some cases to 18 months, you know. So they will say, okay, you are moved into a premise, moved into a place that is being paid for 6 months. After 6 months, they might tell you, well, they can't find any other place. So they come back to you and then they're given an you know, extension. So all those things happened, and you still had delays. And I guess that is what has caught the, you know, the government, you know, one will recall that the government is you know, has set up, you know, a commission of, or some group to inquire into those proceedings, because they found that, you know, it might have been maybe more straightforward and better to just go, how you call it, compulsory acquisition, you know. So that is still to happen.
Because it leads to my next question in terms of if we had used the compulsory acquisition as per standard, as per previous projects, would we have still been exposed to having to meet all those rentals and all of those things? Because when the compulsory acquisition is done primarily through the Commission of State Lands, right? Primarily. Those other things about having to carry the rentals and all of those things, I don't think it's part of that package, is it?
Chairman, through you, when we are negotiating land, and from my understanding, the commissioner, apart from the value of the land, there are other heads that she will look at. The cost of disturbance will be the cost of view being removed. And during that cost of disturbance and other heads, there are other costs that she would add on to the value of the land. So be taken. Furthermore, when you look at land acquisition in its entirety, you're putting one family to place them for the purpose of for a public purpose, be it a roadway or another state project. There's also a social responsibility of a good state and a good corporate governance that you would weigh. So in that aspect, you may look at a heading called rental cost. But the Commissioner of Valuations should recommend a figure that may or may not include such a cost.
Yeah, okay, thanks. And my next question, before going to Member Sagram Singh Suklal, is that, I mean, were we walking into a situation with our eyes wide shut? Because acquisition, I mean, there's a history. I think our permanent secretary in the Ministry of Works and Transport would be all too familiar about the impact of acquisitions on projects, especially projects of this nature. And I mean, we have had a history of litigation, and from way back when Higgs and Hill was doing the East-West Corridor and all of those things. And here we are going into a major project. Acquisition is there because it has been identified, because based on one of your responses here to our questions, Mr. George, in response to question 26, where we asked, provide details on the extent of acquisition that was determined at the time of the signing of the contract with OAS. This is on page 25. It is mentioned that land acquisition for the project commenced in 2009. 2009. So I think that is a reflection of our experience in terms of how long this thing takes and how complicated it could be. And we are entering into a major contract with so much acquisition that has to be done. And although there's an exculpatory clause that we're giving you the site, but we have these things here, a schedule ties us to delivery. And I'm looking at the schedules for delivery of the respective portions under the phases. And the timelines are so tight, very tight, that the timelines are so tight that is not in conformance with our experience in the field of acquisition. And my direct comment / question is, were we walking into a situation where we fully well knew that acquisition was not possible within the timeframes we were given in the schedule? And, or in order to balance that, maybe you can advise us that any special mechanism outside of private treaty, because private treaty to me is just somebody else doing the work, under what I'm seeing here. But was there any special mechanism, or was there a special task force going to be set up between Commissioner of State Lands, NIDCO, Ministry of Works, a sort of a special body of officers that would expedite the whole process and make sure it happens within time? Because it has come to pass that this was a major factor in delays.
Based on the experience, Mr. Chairman, there is no way you could expedite it, and we ought to have known, and we ought to be guided by lessons learned. You don't start any project with that level of acquisition to take place and feel that you could just, it would just happen, because nobody likes to part with their little property, wherever it is. Even if this, and if you have squatters, it's even worse, because there were a set of squatters down there. And I mean, when you, well, squatters have the little shackles or whatever, shuttle or whatever they call them, right? And then they might have a little crop, so you pay them for those things. So they get that. What can they do with it? So you have a problem, you have a big problem with squatters, and homeowners with property owners and things is even bigger, because they could just decide, well, I ain't taking what you have offered. However, you could use the law and, not levy, how you call this thing? Issue a warrant. So you could take over. But that is not, that has so serious social follow, and you don't do that with hundreds of people. The odd person that might be giving you might just be holding out, you might do that with. But even though you have the law, it is not, well, all things is legal, but not everything is profitable. It would not be the sort of thing that you'll want to do. So how do you get around it? Give yourself sufficient lead time to do the acquisition before you break ground, right? As much as you want to get on with it, you cannot, you cannot expedite, you cannot speed up acquisition because people have all kinds of hurdles to put in the road. But if there are, one or two properties, you have a serious time frame, you have one or two properties that you want to get a facility for the public good, then you could apply the law to the hilt where you could not just go through those legal requirements, but you could use the warrant and take possession. But apart from that, it takes time. That there is no system that we can use to expedite, to expedite it.
No, I was just alluding to the thing that knowing the problems of this and the impact it has had on projects. I mean, we would all remember the Weimar situation that kept back that project for so long. As to whether something special could have been done from a coordinating point of view, or maybe some sort of empowerment of a certain group or certain bodies. But anyway, that would be other discussions. But I just, just remember the number. I just follow up on what I was asking, and then we go to members.
Thank you, Chair. Chairman, both you and our chairman, obviously speaking from a position of experience. It dawns on me, though, that were these issues, which seem to be very obvious concerns, ever raised prior to this part of the contract being agreed to, that this would have been a real issue and maybe we should not go down this road? And when I say raised, I mean, again, documentary evidence of this being raised as a real concern and a decision made to go forward regardless.
Mr. Chairman, what I can say is that it was recognized and maybe people were dizzily optimistic. So even in the tender document, because they recognize that they cannot give you all of the site at the start of the thing, what did they tell you? Golconda to Debe, you can have immediately. So we're talking about 2010, they're going out to tender. They say Golconda to Debe, you can have immediately. The other part, Godino River to Monday Zero and what have you, they say, is it April? It's not here, that's a later one. Oh, in the tender document, they said January 31st. January 2011. And then the other one, they said June 2011. So here they were recognizing the fact that they can't give you the whole site at day one. But here's what we're going to do. We're going to give you here immediately, and a few months afterwards, we could give you about 10 or so kilometers, and then the final thing we can give you, in January, and then 6 months afterwards we could give you the whole thing. So that was just optimism. That was just optimism speaking, without any basis, because that has not happened before. And the number of people that you move in, you can't do it overnight. Nobody is just waiting for you to come and even offer them compensation that so that they're going to move. People tell you, I've been here for so many years, my neighbor's string cut there and whatever. They have an affinity, they have a bond to the place that they're at. So when you want to move them, especially move them en masse, if it's just a one-off, you could do it. But you have a number of people to move. I might agree, and my neighbor might say, well, me, I'm moving, you know. And then that strengthens me to sort of dig in my heel. And we have that all over. I mean, Weimar, and there are other places that we can call. But what I do know is that at present, I know about jobs that we are talking about doing, and then the employer say, no, we can't do that because there is too much acquisition to be done. We have to do the acquisition before we could go and engage the project. And that is the approach that should guide us.
So, Chairman, based on what was said, it would seem that because of the sheer impractical nature of those provisions, that component was doomed from the start. Chairman, I just know for my own recollection, I was going through the notes. Prior to this sort of arrangement would not have been the way that the Ministry of Works and Transport and any one of their actioning agents would have conducted a project like this. Was this a standalone in that sense?
Mr. Chairman, I'm not a good history student. I cannot recall. I'll have to defer to somebody else, maybe from the ministry. I'm sorry.
Member, through you, Chair, based on most of the records we can find, this was a unique project in itself. And in terms of the land acquisition, there were mechanisms developed that we would not have developed or undertaken before. In particular, in this mass nature. It's not that...
Or since?
In this mass nature. It is not that the process of initiating acquisition, compulsory acquisition, has never been done, and then you go to private treaty. That has been done before and since. It is the very, I don't want to say largest of the project because that might say something else, but it is the very large nature of the project. So the quantum of people that you're looking to move and to relocate, not to mention the fact that the project was a design bill, which really meant that there were certain aspects of acquisition that you would not have known in detail until you actually get into the full detailed design. So, you know.
Thank you, Chair. Well, as Member Nobrega would have alluded to, I think my colleagues, all of course our distinguished Chair, distinguished Member Morris Julian would have asked overlapping questions that I myself would have had in my mind relative to this acquisition process. But the lawyer in me now, you see, there are certain circumstances that are existing, especially based on what you would have just alluded to, Permanent Secretary, about, as the process of land acquisition began, there may have been unforeseen circumstances that may have existed that you would not have anticipated, that may not have been anticipated. I hear all of those submissions. In law, there is the legal concept of a frustration of contract. And of course, contracts can be frustrated by unforeseen circumstances that may occur during the execution process of the contract that now renders the contract unenforceable. And it arises in the parties' inability, because of those unforeseen circumstances, parties are now unable to fulfill their obligations under a contract. And that area of law, which is predicated a lot on case law, deals with unforeseen circumstances. But I have a serious difficulty in believing that the circumstances that we are alluding to here that may appear as if it's rendering this contract unenforceable, I have a serious difficulty with believing it was unforeseen. Because you're looking at the magnitude of a project, there's a scope of work for a project, the engineers, the ministry, the NIDCO at the time would know where we plan to take this highway to. I am thinking you would know from the get-go that land acquisition is going to be a critical part and a piece of that puzzle that has to be properly put into place if I'm able to take my highway to the place or construct this highway in the manner in which the scope of work alludes to, right? So I just want to begin with saying that I have that serious difficulty in believing, most respectfully, Permanent Secretary, that issues that would have arisen as it relates to the difficulties in land acquisition, that it could not have been foreseen. Because we are looking at a project where there is a scope of work, where where you want to take this this highway to, there are persons who are living there, and you know that one way or the other, whether it's through the use of the act, whether it's through the private treaties, which I'll come to in a bit, you need to move these people in order to be able to execute this contract. And I believe it's more of a poor management and more of an incompetence issue rather than an unforeseen circumstance issue. And that may just be my opinion as to how this project, this land acquisition part of this project was managed. And I really can't see that this issue which arose was as a result of unforeseen circumstances. I believe it was circumstances that was not properly considered before money was spent, taxpayers' dollars were spent. It was matters that were not properly considered by the parties at the time. Certainly you all are not responsible, but at the persons who were at the helm at the time of this contract. So that being said, I want to go to now the whole private treaties scenario. To my mind, and correct me if I'm wrong, if my interpretation is a little bit different from what Chair would have alluded to with private treaties. I am thinking the private treaty was perhaps where the state, whether it's through NIDCO or the Ministry of Works and Transportation, is now engaging homeowners on a case-by-case basis as it relates to their acquiring their land. Is that a fair understanding? So it's a personal contract that I'm entering with homeowner by homeowner. Okay. We are looking at hundreds, borderline in thousands of contract by contract arrangements with persons as it relates to their relocation, correct? And Chair would have asked a question in passing, but it's a serious question. Who is managing, monitoring, and evaluating this private treaty agreement? These agreements, plural. Is there any evidence, because at the end of the day, again, it's taxpayers' dollars that are going to be spent to negotiate with these thousands of homeowners. And this is even more of a serious issue because not being able to move these homeowners is one of the reasons that the contractor is saying, listen, we are unable to perform because we can't have access to the land. So that's a serious issue as it relates to the enforceability of the contract. My question is, again, just to reiterate, is there any evidence as it relates to private treaty, and just to the record for the benefit of the listening public, is there any evidence of what this private treaty entailed, the precedent relied upon, who was managing, who was monitoring, who was evaluating that entire process as it relates to these private treaties. And the question can, whether it's to you, Permanent Secretary, or NIDCO.
Mr. Chairman, whereas I can walk you through, well, the processes, who was managing is not immediately apparent to me, even if I could walk you through those processes. So let me just ask for your, just to be able to report, report specifically on that, not now, but maybe in writing.
Just as a follow-up to the question, in terms of NIDCO's in-house expertise or capabilities in land acquisition at that point in time, was NIDCO set up in a way, or was there internal department that would get up or had a history of tackling land acquisition when this was asked of you all, this private treaty thing?
Okay. Mr. Chairman, we had on staff a very senior and accomplished valuer, Mr. Thompson. He was, Thompson's his name? Yes. He was once, well, I know he has since died, but he was once chairman of the land, the commission? Oh yeah, he was also the commission of valuation. So he was there and so he was the accomplished, competent person that we had on staff, and he would have been overseeing the works of the other valuers that we had in the various teams. So there was a structure there to, because they didn't just go off on their own to determine what the starting thing should be. After the survey, they will go back to that group led by Mr. Thompson and tell Mr. Thompson, well, what they have found, and then on the basis of that, he will suggest what might be a good starting figure for the value that they can ask, what they can start with the owner. So that approach was used.
But the resource, the personnel, your field personnel and things like that, those were in NIDCO at the time, or was heavy reliance placed on private valuers, hiring of private valuation companies to take up this exercise?
Right. Mr. Chairman, those were consultants that NIDCO procured.
Procured.
So we had, I don't know that she will be, okay, I could probably call her name. ACQ. ACQ is a company that has done lots of acquisitions. So let's say we have ACQ, and ACQ is a law firm in this land acquisition thing. So ACQ comes in as one member of her team. She gets a valuer to work with her, and that valuer is well, of course, it's certified, recognized by, she don't just bring on the valuer must be cleared by COV, right? So, and who are the other persons? So we have lawyer, we have the valuer, we have other employees who will help with the social surveys and so. And we have our surveyors who will go out and do the initial survey to determine what the land take is. So with that information now, and even before the surveyor goes out and thing, she will go to do the searches, Red House or wherever else, So she knows who, well, do the social survey, do the searches, so they know about all those things. And once the land take is determined, that information is given to her team, and the team now will go and sit with whoever the owner and start the negotiation. But first of all, go back to the group led by Mr. Thompson. Say, well, what she has found, how much land, what is there on the land, because you had to pay for crops and what have you. And so they will come up with a value, and she would, armed with that value now, she goes to meet with the landowner or the property owner who also has a value working with him. So then they'll work together and come up with a value of the property. If there is no meeting of the mind, that is referred to the COV for resolution.
So I understand that, because in a previous incarnation, of course, I would have done a lot of land matters myself, right? But my question is, but when is, okay, so I hear the process, I understand the process, it's something I can accept. But when is this done? Is this done while you're already swimming and you're already in the middle of a contract? Money spent, taxpayers' money spent, work mobilized, and this negotiated, this onerous process, to your mind, best practice, now let's go to best practice. Is this done prior? Isn't this part of setting the stage for the execution of a contract? Or is this done, this process is done simultaneously? So you start your contract, money spent, work mobilized, contractors mobilized, they're running with it, and then you're now putting things in place to see, with the hope and the anticipation that you could settle and negotiate with homeowners. To my mind, that seems like a flawed process. To my mind, and I could be wrong because I'm not a contractor now, I'm not in the business of building highways and all of that, but just to my rational mind, I'm thinking, wouldn't those be things, especially given the magnitude of this project and the amount of money, and in this case, given the magnitude of settlers and people you have to relocate, wouldn't you think realistically, practically, logically, that this is something that ought to have been anticipated, and that process of land acquisition ought to have been considered and dealt with prior to all of these other steps as it relates to the execution of the contract taking place? Or is it normal that, because I don't know, is it normal that, yeah, I have thousands of landowners I have to settle, but you know what, I'll go ahead and I'll start this contract with the hope and the anticipation that, yes, maybe I will be able to get these people to move. I mean, to my mind, it's just not, I would appreciate your professional take on that process. So yes, I know, I take the evaluation, I know how that works. Timing, if you could probably shed some light on that.
Okay, Mr. Chairman, as I, already suggested, that, what the member is alluding to is quite valid. I've already suggested that it is bad news to start construction without settling the land acquisition problem. Land acquisition should be precedent to starting of construction. Anyhow you try to do it differently, you'll run into problems. And we had it, it was demonstrated in a very vivid and maybe costly way on the Solomon Hochoy Highway Extension Project. So yes, I'm agreeing with you, with the member, that it should be done before. And I'm further saying that we are in fact observing some of that now, because from where I sit, I know about projects that the employer would like to start, but has said, no, we're not starting it because we have to sort out the land acquisition issue. So yes, that is the way it should happen. Get the land acquisition out of the way first before you start the project.
but the project started, unfortunately, so it seems to be that there was some haste, some reason why, notwithstanding these contracts being, the land acquisition matter being settled, this contract for some reason just had to start. But that's not for you to answer, that's just my comment on what has been transpiring so far. Litigation now, Chairman, through you, Chair. You have had, I think in your oral submissions just now, you mentioned about general litigation coming out of this land acquisition. Can you elucidate on that point? How much matters went before the court? What kind of taxpayers' dollars were spent because, again, of not properly dealing with the issue of land acquisition prior to the commencement of the contract?
Mr. Chairman, well, we have a handful of matters, maybe about 6 or so large owners handled by COV that they have, we had there's a disagreement as to what they'll accept for the land, and those things are being litigated now in the courts. So, you know, those are the large people. I mean, I don't want to call their names here, but just a few.
And Chair, if I might, through you, how much money, for the benefit of the public, how much money was paid off generally for land acquisition? How much of taxpayers' dollars were paid for that whole acquisition process, land acquisition process?
Mr. Chairman, if I might just refer to a summary table that I have here. The number of properties of interest, 513. Paid, $466,410.95. $410,095.91. Balance owed on those properties, $1,481,455, giving you a total of the value of those 513 properties, $467 million. But let us see, round it off, $468 million.
That was as of what date, if I may ask, Chair?
All right, that is current, but that is properties settled. But you have properties that yet to be settled, and it is it is in abeyance because the government of the day, they want to have a handle on things. What has happened, and so this is when they you remember about the commission of inquiry that was announced is to inquire into those areas and see what has happened in cases where we had critical properties that were dead in the right of way. In order to allow the construction to take place, to go down to point, they gave specific approval for those properties that were directly in the right of way and that were just holding up construction. But there are other properties that are to be settled. Okay?
Chair, through you, to Chairman, Chair, that document that you're referring to, can you refer us straight in our bundle, or is it something that we would need to have in our possession? If we don't, can I respectfully make a request through you, Chair, for us to have sight of that document that spells out the figures of monies that were expended, for that private treaty arrangement, compensation, all of those things. Chairman, can I just briefly continue? So just as a matter of summing up, generally my line of my concerns. Now I know as it relates to the, and I don't want to belabor the point, but as it relates to the relocation of persons and compensation, of course, I know one of the members would have alluded to the Land Acquisition Act, right? Beyond the law, the Land Acquisition Act, is there any policy paper, any working paper, any policy that exists written, that speaks to written guidelines established for the relocation and compensation of affected persons? At that time, was there any written, did you all come across any written guidelines, any document that was relied upon for this process?
The legal requirements are the legal requirements.
Correct.
We should just follow it.
Which is the law.
However,
right.
The World Bank has some guidelines in what they call the involuntary resettlement of people.
Right.
And they suggest ways, well, not so much ways as how you should treat with those persons, so that they must not be placed in any disadvantageous position after the process. So you have to try and preserve their stature, position, or whatever.
Status quo.
Status quo. Preserve it. Thank you very much, madam.
No problem. So is it that during that time, it would have been that same document, those guidelines? Is it, or are you speculating or hoping that that is the process that was used at the time? Was that, I'm asking, because, and I'm not being facetious at all, is it that, so I could understand the best practice of the current board. I could understand the best practice of the ministry now, bearing in mind that there are these guidelines provided by the World Bank. But is there any, because when you started off, you said you're relying upon, you don't want to speculate, you're relying upon data that is before you, information. Is there any written document that suggests to you, Chairman, most respectfully, that this is a guideline that was being relied upon when it came to relocation? And I'll tell you why I'm asking the question first, is because to my mind, this is really being done haphazardly. This whole process, to my mind, is flawed, the way in which this whole land acquisition was done. But I want to know if there is a record, any kind of record that suggests there was indeed, beyond the law, which is the legislative part, yes, there's the act, if you would, in your readings, your investigation, you would have come across that document that was relied upon.
Mr. Judge, before you answer, let me just, Ms. Yewood, in your response, the ministry's response to the committee to question 25, which is on page 5 of 7 of your response, when we had asked to provide details of the property acquisition process that was used for the project, at the bottom there of the page 5, circa November 2012, you have stated, Ministry of Works have stated that cabinet approval was granted inter alia for the compensation policy for the individuals affected by the land acquisition for the project. So apparently there was a compensation policy that was developed based on your response here?
Yes, Chair, there was an approach to Cabinet with the process that was recommended from NIDCO as to how to deal with the land acquisition process. This would have come out, the land acquisition process would have started in the normal way in terms of we would have gone for compulsory acquisition. The time that was recorded being taken was identified by NIDCO as being onerous to the project, and there was a request for, another process to also be undertaken, and that would have gone to Cabinet and gotten approval. And it is from there, that approval, we would have had that interministerial team, which would have interacted in the valuation and the compensation process. There would also have been Cabinet decisions that spoke to the issue of, for instance, the grant of land at different sites and what was to be done, etc.
Chair, if I may, respectfully, it's the interministerial team. I'm not sure if Minister Morris Julian would have, Member Morris Julian would have alluded to that. This interministerial team played a part, based on what you're saying, even in the compensation process?
The team that I am referencing was specific to the compensation process, in that the valuation, the affected party would have had their valuer, NIDCO would have had their valuer, they would come to a position. That would go to the interministerial team, and based on the recommendation coming out of that, that would then go back to NIDCO's tender and committee and board, where the decision would have been made to pay or not to pay.
So, Chair, just so I can see it clearly, so you have, I'm just asking, so you anticipate that what would have happened, that, not anticipate, but in your mind, what would have happened then, because I'm trying to clear up my thoughts. So you have all of these applications, negotiations, treaties going before this interministerial team, that they're in those contracts or those agreements would speak to what compensation, terms of compensation, time for relocation, all of that. Is it that that is what goes before the interministerial team for the interministerial team to consider, and then when a decision is made by the interministerial team, that then goes to NIDCO for NIDCO to then say, well, with an instruction that yes, we accept or yes, we do not accept?
I'm trying to make sure that it is not based on the documentation. The documentation is saying that the property owners would be invited to engage at NIDCO, at the NIDCO level. Then there would be a negotiating consultant, attorney at laws with their licensed valuers, and they would meet and they would come to some sort of position, as the chair would have alluded to. Then that would go, NIDCO would submit that to a cabinet-approved land acquisition oversight committee.
Which is the interministerial team?
It would have had representatives from Ministry of Finance, from Ministry of Works and Transport, Ministry of Housing and Urban Development, and someone from NIDCO. And then that team would then review what was done prior and make a statement on it, and then it would go to NIDCO's board, who would have the final say as to whether or not it's accepted or not.
Thank you for those submissions.
Yes.
Yeah, Member Denobrado.
So Chairman, through you, there was just, I keep coming back to, as we go through this, the lack of reporting and a sort of lax approach to oversight along the way. And so I apologize for pulling us out of this for 1 minute, Chairman, but just for my own notes here. We've spoken about value for money, and value for money comes as a direct result of quality oversight. So through this entire process, and in the particular case of the IPCs, so payments being made to OAS, I'm wondering if between NIDCO and Ministry of Works and Transport, if you can walk us through the process of OAS making a claim, the validation or certification of that claim, the acceptance of the validation, the forwarding, I'm assuming that that step is the last step at the NIDCO level, the forwarding of that to the Ministry of Works, what process takes place there, and the mechanism to actually pay OAS. And in particular, what I would like to know is, what are the checks and balances along the way to validate what has come before?
Mr. Chairman, what happens is this. The contractor submits a payment claim, and he submits that, in that case, to ECOM. ECOM is the project manager there. That claim is evaluated. ECOM will share that with NIDCO. And NIDCO has
Chairman, if you wouldn't mind, when you say it is evaluated, is that a physical inspection to evaluate lengths?
All of the above. Because you have a work breakdown structure. So it says, let's say, in this job you have 30 or 3,000 meters of concrete to pour. You're claiming here 300 meters. So where did you pour 300 meters of concrete? So that must be identifiable. So the project managers down there, they have people to check that. So once you check and you can see, well, yes, that is where the 300 meters of concrete were poured. So that could be accepted as part of the, as an item in the valuation, in the claim. So they'll go through that process, and at the end of the day, they'll be able to ascertain that the work that is being claimed for has in fact been done. And that now will go to the program manager. That's a NIDCO's person now. NIDCO's person must go through the claim and ensure that what is being claimed for there is in fact, how should I say, is reasonable, has been done, and it is good to sort of, it is okay to present it for payment. So once he goes through that and he's satisfied that the items that are being claimed there, check whatever rates or whatever, all those things are checked. Once it checks out, even the arithmetic too, once it's checked out, he then proceeds now to, certify that IPC. And once an IPC is so certified, it will go to the line ministry, in this case, Ministry of Works, for payment, drawdown of funds to pay. And once it goes to the contractor, that's like a legal document. You can go to the bank with that if you want. So we don't expect the ministry to say, well, no, I ain't paying that, right? So the ministry will expect that those checks and balances will be done, because once IPC is issued, that is it. So to get to the point of issuing an IPC, you have what? Claim by contractor, checked by the ACOM, checked by the program manager of NIDCO, they call it issuing of IPC, and that goes to the ministry for payment. Yeah, goes to the ministry. Oh.
So, yes, so the chairman has identified the process, which it is normally done, yes. The one thing I would like to just add is that in this case, we have to recall that the funding was via treasury deposits, which meant that the funding was placed in NIDCO's hands. So that is where payment would have been finalized. It would have come to the ministry. We would have kept a record of the payment and also a review of the IPC to ensure that, that there wasn't a payment that was doubled or an area that was identified before, and of course, all the mathematics, etc. In this instance,
of course,
based on the type of funding that was undertaken for the project.
Well, of course, we've already seen some instances where there was exactly that, a double payment. So,
we haven't seen the IPC.
No,
we've seen the document for it. Yeah.
Understood. So, up until the point, at the point that it leaves NIDCO is the last time that a physical validation of the claim would have or could have been done to say this was supposed to have been done and here it is. After that point, and when it gets to the ministry at that point is just, I suppose you are looking at the contractual arrangements and making sure that that it is in line with the funds and you're not paying past the contract sum and those sorts of things. So, Chairman, and bear with me, I'm working out, I'm trying to get through a scenario here. Let's see, and it is not beyond the realm of possibility. You have a contractor. The contractor puts in a false claim. The claim is false, and the person who is to validate it is lax in their validation, in their own part of this process, or they're in cahoots. And then, so your first two stages are compromised. And then the third stage is just somebody who's signing off on the project because I trust the first two, or at least the second stage. By the time you could get to the end of a payment and not necessarily have gotten that value for money that you're supposed to have gotten with that process. So therefore, more than anything, I would think that your project manager is that sort of most critical stage because the project manager's value is validating the initial claim, and it may very well be on the say-so of the project manager that the program manager signs off. Am I correct with that?
Yes, except I want to introduce that any error on an IPC can be corrected on the next IPC. So if I overpaid you now, because people are in cahoot, I would hope at some stage it will be looked at closely and that will be discovered so that it can be corrected. But errors can be made and it can be corrected on any subsequent, well, I say the next. In other words, any next, on subsequent IPCs.
And it brings me to what eventually was paid for as opposed to what was received in terms of the entire project. So, in terms of the entire project sum, what percentage of the entire project sum was actually paid? So you have to ask two things. Was actually paid to NIDCO and then paid to OAS? Because NIDCO would have received payments, 5 payments, I believe, from Ministry of Finance, Ministry of Works, and then the bridging loan. And I think that was about 5.1 billion. So that would have been paid to NIDCO. How much of the projects, a percentage, rough percentage, was actually paid to OAS?
Mr. Chairman, I have with me a statement a report that I got from that came from AECOM, and that's the FIDIC engineer now, and it was dated 2016. Yeah, February 2016. So pretty much the end of AECOM's tenure, AECOM's involvement on the job. And he's reporting, right, he reported here that, and I'm talking US dollars here, right? He said the design and preliminary works, $108 million were paid to OAS, 21% of contract amount. Construction works, excluding 2A, $457 million. Construction amount, that is excluding 2A utilities and provisional sum, $525 million. Claims paid, $53 million. So what we have to add here now, 457 well, this is 525, right? So we have to add 525 and 53, that's 578 million dollars, US dollars. And then what's the contract? So what's the budget?
So Chairman, I am basing this on the the initial report from NIDCO. And the initial report from NIDCO at page 25 of that report, in a summary, and this summary basically is a summary of tables 3 to 5, and tables 3 to 5 would have considered the main elements of the project completed by OAS during your tenure. Page 25 of the actual NIDCO report. So
not the response.
No, your actual report, not your responses, your actual report. I apologize, the Saga. Thank you, Pierce, thank you for clearing that up for me. It summarizes table 3, which is on page 23, table 4, which is also on page 23, and table 5, which is on page 24. And that speaks, amongst other things, to NIDCO having paid 68% of the budget in procuring 49% of the physical works. And in there now, and I understand that there are things outside the physical works, right? But it is still my concern here that are you, Chairman, satisfied, having reviewed the records, that that process of oversight, that process of validation was a process that had integrity, outside of the obvious human error that could happen, that there are no red flags in that process?
Mr. Chairman, I should point out, when it is said there, it is 42% of the works. If you notice the table on page 23, it really deals with raw works. When I say raw works, physical works. There is no design here. All right? So one has to just be mindful what one means by that. One is not saying that they have been paid. In terms of what you can see, they are, that is what I'm talking about here. So they have been paid, what, 68%? Where did I see it? 68%, but it has been put in procuring 49% of the physical works. So the prelims and so might not be, would not be here, right? The designs will not be here, and other associated services. So one just must bear that in mind as one.
I completely do, because on table 4 looks at the design component and the construction component, and says that as a total, there's 49% of the design construction component. So, and it's on that basis that I am asking that if there were any red flags that would have been thrown up during the process of reviewing this. Because if you've completed 49% design construction, you've paid, based on this, 68%. And it says that there was 2.4 billion left in the budget, and that was insufficient to complete the 51%, and that 51% would have not only been construction, but it would have been the additional design components, because even the design had not been completed. And coming out of that, and again, Chairman, there's a lot that has been said over the last 2 days. The things that strike home to me through this entire process is decisions being made, and there is no paper trail. And critical decisions, there is nothing that validates that decision from a person who could be held accountable for it. Payments being made, and in some cases, you don't know where the authority was to make that payment. And now, at this stage, I'm asking, is that also a concern? And I know, I mean, you can only go back to the records that you have, and the same for the ministry as well. Is that a concern, given what we're seeing here, given the disparity between what has been received measurably, even, I suppose, as best as you can measure the design part of it, compared as to what we paid? So the question still remains. Are you satisfied, given the records that you have been able to see to this point, that that process, there was integrity in that process? Again, and I understand completely that there can be human error. As you rightly say, you can make a mistake in this IPC and correct it in the following one. We have a negative IPC in this lineup, right? But it seems like so wide a disparity between what has been paid and what is received.
Mr. Chairman, if the question is, am I satisfied? No, I'm not satisfied. I'm concerned that a contractor has been well treated. He has gotten everything that he wanted, he got. Except that when he now had to produce, all of a sudden, there's a lot of excuses. And what he actually produced does not measure up to the sort of goodwill or the sort of payments and so that were made to him. And when it comes to his production, we hear about the difficulties, the delays. We hear about you hear about the delays. And when this contractor was gotten rid of, this contractor was owing everybody in Trinidad.
So, Chairman,
so where did the money go?
And again, this is also the concern for me, because that also is an issue. You have, I think it was 1,000 workers thereabouts that had not been paid for however long. You had outstanding contractors, but at the same time, he has still received all of this money. And if you couldn't, I can't bring myself to the point where I can rationalize that you have these contractors, as you had laid it out, who have also produced performance bonds. So they know that they have to produce the work that they're supposed to produce. Otherwise, they will lose their performance bonds. So you have these contractors. You are owing them money. You have received money that you have not paid to them. But at the same time, IPCs are being signed off. And I suppose I'm trying to get to the point, Chairman, that when we are finished here, obviously we are going to have to speak to other entities, persons and entities. And from a starting point, I am trying to get down to where are the gaps and how best can we explain or point to things that simply cannot be explained, obviously by you, and somebody else has to do it. And this keeps nagging me that they must be here. For you to be signing off IPCs, the contractor bringing any claims for it is being paid. It is going through the process. He gets paid for it, and we get less than half of a project completed, design and construction. And even while that is happening, subcontractors are not being paid, but they're still producing. Workers are not being paid, but they're still working. It is, my rational mind cannot get to the end of it. So I just wanted to get to that point where, and I suppose I am holding on to my earlier request that there must be professional opinions that add value in this conversation. It's just, feel your president may be whispering quietly to you to hold your tongue. But I can ask, the question I have asked holds, are there any red flags that have stood out to you during this process, in particular to the oversight? And I would like to ask the same of Ministry of Works. Any validation? Was there anything in reviewing those things that stood out to you all in terms of how these things were being paid? Chairman, I apologize for being long-winded.
You know what, Mr. Chairman, you know what bothers me? When you look at the processes, okay, you have a negotiation committee, negotiation team, with an august set of people on it. You have somebody who, when you look at the teams that they put together to do the work, they look impressive, But the work apparently either was not, well, I can't say the team did not work, but the action to be taken, having done the work, was maybe centered in too few. So the good work that the team was doing don't seem to have come forward, right? So I can't fault your evaluation team. I can't fault your tender committee. I can't fault your, but yet that's what we got. So that, Mr. Chairman, I'm still looking at. I don't understand it yet. I'm trying to wrap my head around it. So I'm sorry, I cannot give the direct answer to the member.
Okay, so I think we have to start wrapping up. Ms. Would you wanted to add anything based on what member De Nobrega was saying?
Chair, I was just wishing I was in Ms. Farmer's position and I had a chair I could whisper to make statements. But they often say that hindsight is 20/20 vision. But there's a term that has been used right throughout this meeting about things being hazy and cloudy, even in hindsight. So there are, when you look at the documents, because that's what we've had to do, there are certain steps that, based on our present practice, of course, we would question. And there are a number of areas, as Member Sagram Singh Suklal would have mentioned in terms of acquisition, that is a natural way that you would do it. It's a major risk that you would identify in any project. And then you would seek to put things in place to mitigate that risk, as the chairman would have alluded that if we could not have found something to mitigate that particular risk, the nature of the risk being so large, being that you probably should have dealt with it prior. So I'm saying all that to say, member, that looking at the documentation, there are areas that one would want to question the process. The lack of information, documented information, however, really hampers you from making any categoric statement, because you're unaware of exactly what would have happened based on the lack of physical documents in certain areas.
Okay, so I'll allow one final question from Member Julian.
Thank you very much, Chair. Chair, actually this question stems from the public, and they start off with a quote, "Who will guard the gods?" And it is directed to the Ministry of Works. Considering the controversies and issues surrounding the Solomon Hochoy Highway Extension to Point Fortin project, including allegations of government betrayal, amended contracts, significant financial losses, how did the Ministry of Works currently, how are you ensuring transparency, accountability? Now, we would all be familiar of many major projects where the prices were cut in half. I would even go so far and say a quarter. Yeah, I would. And in the infrastructure projects, what has been done, what is being done differently to prevent similar situations from occurring, other than the fact a different government? Thank you very much. Well, the person didn't say that. I just added in that part. And it's directed to the Ministry of Works, because I know it's the governing authority, but of course they would listen to the cabinet at the time, and NIDCO is pretty low down. They're supposed to execute, but there were other people in charge at the time. So I think this person just wants to know how we are making sure that something like this never happens again.
Yes.
Chair, you would like me to respond?
Yes, please.
I note the member's last statement as to how we can ensure that this never happens again. And I want to take us back to the statement by the chairman just a little while ago, where he stated that we had systems in place, in that there was an evaluation committee, not made up of any fly-by-night members, if there's such a thing. There were monitoring teams, once again, not made up by any one entity, but across the government. And it appears in this instance that it did not work. So one may reach the conclusion that the challenges experienced on the project may have been even wider than that. What I can say at this point in time, the system that we have in place for undertaking projects speak to the genesis of a project at a given ministry. The ministry would identify the need based on its reconnaissance, its analysis of the situation, etc., and a project would be developed. That project would take in the requirements in a specific area, inclusive of the infrastructure requirements, the social requirements, etc. There would be an indicative cost that would be identified either by ministry personnel or by a consultant that may have been hired. This would then go to the cabinet of the day, which is where approvals for projects such as these would be undertaken. When you submit it to cabinet, you would also submit a governing structure as to how it is to be implemented. If it is to be implemented within the ministry, you'll have another process that you undertake. It would be assigned to a specific division. Within that division, you would have monitoring engineers or officers assigned both to the technical as well as to the financial aspect, as well as to the scope, and that is what is done now. You would also have a review at times by in our instance, we have a chief technical officer who would review it intermittently as required or asked by the permanent secretary or some other member. And that is how we seek to implement our projects now at the ministry level. We even, at times, if it is necessary, seek to get someone external to have an overview of what is happening on the project if we find that there is a challenge. So that's internal. If it is that the project is not to be implemented by our internal resources, and we then have to bring in an implementing agency, which in this instance, for that project, it was NIDCO, and many of our large projects are being undertaken by NIDCO at this point in time as well. The project would be assigned. We would write to NIDCO and we would let them know what is the intention for the project, what was approved by Cabinet, and any documentation that we would have. NIDCO in turn would develop their internal tender documents, etc., which they would put out. And one of the interesting things that was coming out before, which, well, I want to say it does not happen at this time, and I'm saying that based on the copious documents we sent NIDCO in terms of if there's an approval for project, and the copious documents that the president sends to me if it is, she's of the view she's being asked to do anything that is not documented. So we have ensured that those mechanisms, they are in place, and NIDCO implements. Now, when we say NIDCO implements, they're implementing on behalf of the state, the contract document, etc., but generally reflect what is required by the state. The employer under the contract for the project is NIDCO. We do have mechanisms we monitor in terms of the IPC, which comes to the ministry, and the funding, when the funding is under the ministry does seek to do a deeper dive in to assign an engineer to the extent possible to be able to meet with NIDCO if necessary, if there is an issue. Yes, so we take it to that step further, and then internally, the ministry also does a document which is signed off by the engineer, or in this instance, if it's a highway, the director of highways, because they do more than highways for us, the director of highways, which then comes, it's a payment certificate, which then comes for the permanent secretary to once again sign off on to indicate that yes, this has been reviewed, we are in agreement with what has been submitted by NIDCO to the extent that we have checked certain basic things. Bearing in mind that in NIDCO there are, as you rightfully stated, at least 3 levels of checking. And all of this it's a well-tried and a tested system. Now this last statement that I am going to make, I have to make sure that I have a couple more years, so I can say it. The issue in my mind, the systems are there. The public service has systems, and the systems are there. People have to make the systems work, and people have to keep the systems accountable. Yes? So, and I'll stop there.
Okay, thank you very much, Ms. Yearwood. Actually, I would what you have said there, I would take it as, I think it could be taken as closing remarks. Because, yeah, well put, yeah, so at this point in time, I would like to, thank all of the officials who have attended today's hearing. I would like to thank you for your sharing of information. I know at times the questioning could be taking you into the realm of speculation, particularly in a situation where documentation is not readily available, and the extent of the documentation, even though it's limited, it's still voluminous, and we have to be sifting through. But I think I'll thank you for your cooperation in trying to understand the committee and our questioning, because we are really trying to get things as clear as possible in our minds as we go down the road, so that our deliberations are fruitful and meaningful and could have, positive impact on how we do things going down the road as a country. So thank you very much. And to our listening audience and our viewing audience, thank you once again for joining in. Committee members, my appreciation to you all. And of course, our Parliament staff that makes all of this possible, the Secretariat, and also our technical crew, and other Parliament staff. Thanks. And at this point, I'll suspend the meeting, but I'll invite members of the committee, if you could please stay back for a short post-hearing discussion. So thanks once again.